Good morning, everyone, and good afternoon, good evening to those of you who are joining from country offices. Welcome to the World Bank Data Privacy Day. My name is Riaz Ahmed. I'm the Director of Operational Risk, and we're here to celebrate Data Privacy Day. It's an international effort to build awareness around privacy. This is the fourth event that we're hosting. We want to use today as an opportunity to share with staff some of the contemporary data privacy issues through a series of engaging discussions that I hope you will find interesting. Data continues to grow exponentially. In fact, some statistics I pulled out of the internet suggest that we already produce and consume over 90 zettabytes of data, and that is projected to double by 2025. I think this reiterates the importance of safeguarding personal data, as that will also likely grow. And the bank continues to make excellent progress in this area over the last few years. Some of you have been directly involved with the implementation of the data privacy policy. We are also, as a team, working with business units to provide solutions both on storage, protection, disposition of data. Training and awareness is a major part of the role that we're playing, and ensuring that staff understand the requirements and the importance of compliance. It's really a privilege today to have Lakshmi Shamsundar, the World Bank Chief Risk Officer, who in fact has spent time in all of the three World Bank Group institutions, IFC, MIGA, and the World Bank, but she's also, in her previous life, was part of the faculty at MIT Sloan and Dartmouth. So please welcome Lakshmi.
Thank you, Riaz, and good morning, good afternoon, and good evening to everyone joining, all of you physically here. Greatly appreciated that you've actually taken the pains to come in physically, because that creates a dynamic that is different from an online, but equally very interested in all the online participants. And I'd like to welcome you on behalf of the World Bank for our annual Data Privacy Day. As Riaz said, this is the fourth consecutive year that the World Bank has organized this event, and it affirms our recognition of the importance of data privacy and, more importantly, the responsible use of personal data. The world of technology, privacy, and data protection has changed significantly since our first data privacy event in 2020. The increasing digitalization of the global economy, accelerated by the worldwide pandemic, home-based work, have all led to unprecedented growth in the collection and use of data, including large volumes of personal data. We are continually inundated with requests for personal data in both our personal and our professional lives. At the same time, developments in technology continue to disrupt industries and organizations globally, presenting both opportunities and risks. On the one hand, new technologies such as artificial intelligence and machine learning can capture insights from data, leading to greater business efficiencies, better services. But on the other hand, increasing digitalization, crowd migration, and the need for data sharing and analytics have greatly exacerbated data privacy risks. As data's value rises exponentially and more data privacy laws are enacted globally, data privacy is no longer a narrow concern. It is a critical business opportunity, and preparing World Bank staff and the larger community for this challenge through greater awareness building is one of the key strategic objectives for Data Privacy Day. As many of you know, the World Bank is owned by 189 countries, with operations in 170 countries, with offices in 130 locations and 16,000 staff. Our objectives are to end extreme poverty and build shared prosperity across the globe. In doing this, we draw heavily on data to perform our work in the design and implementation of our operations, and much of our work directly affects individuals in vulnerable and marginalized communities in developing countries. The World Bank also compiles development data for a variety of purposes, including monitoring the pace of economic and social development and tracking the status of the environment. In this process, it is entrusted with large amounts of personal data, often sensitive, from its various stakeholders, including governments, project beneficiaries, non-governmental organizations, civil society organizations, and staff. As explained in our World Development Report 2021, data protection principles are at the center of our efforts to develop the digital economy. As data protection, data privacy, and data security provide the very foundation of digital platforms to build and maintain public trust in our organization, it is necessary to understand the cutting-edge issues and trends in data privacy, and also keep abreast of best international practices on the use of personal data responsibly. Moreover, as personal data incidents become more widespread, greater vigilance is required to safeguard the World Bank's legal, business, and reputational risks. The World Bank Data Privacy Office has an important role to play in this environment, with the growing threat of data breaches and the increasing importance of managing and protecting personal data and associated risks. The DPO function at the bank will continue to build on the excellent progress that has been made so far in designing and implementing the World Bank Privacy Program to provide solutions to business units on the storage, protection, and disposition of personal data, the training of staff, and building awareness around our data privacy policy. In this context, I am very excited that today's Privacy Academy, curated by Professor Daniel Solo, and the lunchtime talk featuring Professor Ryan Kalo, both internationally renowned privacy experts, will help you understand the evolving context of data privacy issues, and especially in this changing global environment. So I wish us all a very wonderful learning experience. And with that, I will hand the floor over back to Riaz. Thank you.
Thank you, Lakshmi. Thank you very much, Lakshmi. So I think, to start off our session today, there is a lot that has been taking place around data privacy, and I think we have really, we're very lucky to have Professor Dan Solov to give us an overview, if you like, of where data privacy is headed. The subject has grown clearly, and it's kind of important for us to kind of have that, high-level understanding of the direction in which it's going. Professor Dan Solov is at GW. He's also the CEO of Teach Privacy and is a renowned author in this space. So welcome, Dan.
Hello, everyone. Thanks so much for having me here today. The topic of my talk is lessons from the frontier of privacy. I've been studying and teaching privacy for about 25 years now, and I've seen things grow and evolve, and I have some thoughts about where things were, where things are now, and ultimately where things are going. So I'd like to share with you some of the insights I've learned, some of the lessons that I've picked up along the way as I've studied and taught and talked about privacy for all these years. But before I get into this, a number of people will say, and I've heard this a lot, that privacy is dead. Privacy is gone. So this is a little bit disappointing since this is what I do. But folks say this. However, when you look over time, people have said this for quite a long time, in fact. Go back a few years, Wall Street Journal says privacy is dead. Go back a little bit further, privacy is dead in 2015. Get over it. 2015, Science Magazine, The End of Privacy. 2014, looks like the end of privacy there. And if we go back, 2013, is privacy dead? The end of privacy. Here we go again. 2012, the end of privacy. 2000, let's skip because we can. There's something every year. 2000, the end of privacy. 1999, the end of privacy. 1997, the death of privacy. 1995, again, privacy died in 95 and 97. 1983, who killed privacy? So, 1970, is privacy dead? 1969, the death of privacy. Will privacy ever stop dying? Because it's the longest death scene ever. Even Hollywood couldn't produce something quite like this. Very dramatic death scene. Privacy just keeps dying and dying and dying, but doesn't seem to really die. I made this cartoon talking about how all the ages of technology, there were concerns about privacy, and people were wondering, is privacy dead? Starting off in the 1870s, the telephone was invented, and then wiretapping started, and folks said, well, this is the death of privacy. 1880s, portable cameras were invented, and Warren and Brandeis in 1890 wrote a famous article talking about the right to privacy, how there was a big threat to privacy by cameras. 1960s, with the rise of the computer, again, concerns about privacy. 1980s, as computers got smaller and now no longer mainframes, but personal computers. Continues, 1990s, we started to have portable phones, and again, concerns about privacy. And then portable computers, smartphones in the 2010s, which now we all have. And again, everyone was concerned. And so I projected this out into the future because this seems to happen with every technological invention. My prediction is by 2070s, but maybe even sooner, we'll have what's called holographic life projection, where you project your entire life in a hologram. Who knows what we're going to have. But there'll be new technologies all the time, and there'll be challenges to privacy all the time. But I think, in fact, that far from dying, privacy is actually in its heyday. This is prime time for privacy, not the death of privacy, but in fact, this is a golden age for privacy. We are seeing really profound developments in privacy law, in attempts to address this problem, in attempts to regulate it, develop best practices, and develop regulation. So when I look at things, I see not a death, but in fact, really profound growth. Now, I still think that privacy has a long way to go, but I am encouraged, in fact, optimistic, because what I've seen over the 25 years I've been looking at this is really dramatic growth. And I'd like to talk about some of the things I've noticed as that growth has occurred. And one of the major differences between when I started and now. When I started, it was looking at privacy. It was the late 90s, and there were hardly any privacy professionals. A handful. I could count them on one hand, the number of privacy professionals. I could count the number of academics looking at privacy, also on one hand. There were a few people. This started to change. At the turn of the century, and starting then, more and more organizations started to require and have privacy professionals. Laws started to mandate that there be privacy professionals. And we've seen this profession grow dramatically. And if you look at the numbers in the profession, the IAPP, the International Association of Privacy Professionals, starts off and there's a few hundred people, and then 1,000 people, and they're happy that they have 1,000. Then 20,000, 30,000, 50,000, and more. The number just keeps going up and up and up and up. And so we really are seeing something really dramatic occur. So we've really seen this just dramatic growth, and now beyond just one person at organizations, we have many people at organizations, in fact, teams of privacy professionals at a number of larger companies and public organizations. So this is really, I think, quite amazing, going from, in such a short amount of time, to see such a dramatic increase in the number of people who are dealing with this problem, thinking about this problem, trying to solve this problem. I really think that's a remarkable development. Now, when I began looking at privacy, I focused almost entirely on the law. And I thought privacy kind of begins and ends with what the law says. And then I'm a law professor, so that's kind of what I do. I look at the law. But one thing I've learned by studying privacy over time is that the law isn't the only important component for how privacy is regulated, how privacy is protected. And the thing that I didn't appreciate when I started, that I really appreciate now, is that the implementation of the law, the people that are involved, the way that things are implemented, and the practices that evolve in privacy really matter. They matter a lot, much more than I thought. And I'd like to talk to you about this theme, because there's a theme throughout what I want to talk about today. It's just how important these things are and why these things really are the ballgame. So, one thing that we've seen over time is that the privacy playbook has evolved. Because when we started in privacy, there really wasn't much of a playbook. So you have a privacy professional and they write a privacy policy and that'll be all they do. What else would you do? And no one knew what exactly protecting privacy actually meant. So this was a problem. Flash forward to today, there's a much more robust playbook. Someone starts off as a privacy professional and there are things that they do. They know to do data mapping. They know to have policies. They know to do data protection impact assessments. There's a lot more consensus over what is entailed to protect privacy. And I think this is a great thing, this development now, that there's a body of knowledge and a set of activities and practices that are about protecting privacy. And this just didn't exist in the early days. People would be anointed privacy officer, and then they'd be like, what do I do? And the upper management of a company or an organization, we don't know, just do something. But now we know a lot more what to do. So I think that's a great development, and that's really important. The effectiveness of law depends on people. This is a lesson that I think is incredibly important. Law is not self-executing. You can have a wonderful law, and it can fail. And it will fail if you don't have people to implement it. Because ultimately, enforcement can only go so far. You can't enforce against the universe. And most enforcement agencies have significant limitations. They have budget limitations. They have size limitations. They can only enforce to a certain degree. So privacy depends on organizations doing things internally. And if those things don't happen, well, privacy laws might say certain things, but ultimately those things aren't actually going to get done. So it's very important that people carry this out. And what also matters is how well they carry it out, how well they do this. Because there are many ways that this could be done. The laws are often not very specific on precisely how things are to be undertaken. And there are good ways to do it and sort of not so great ways to do it. And I'll talk about that a little bit later. I think without the privacy profession, privacy laws would have had much less of an impact. As we've seen privacy laws created over the last 25 years, a lot of them would not really be able to actually be effectively implemented without privacy professionals, without people. You need people to carry them out, because a lot of what these laws require are things that go on internally at organizations that have to be done by somebody. If someone isn't actually doing that and carrying it out, the laws are just not going to work. And I've seen a number of privacy laws, and when there's a privacy law that doesn't require that there be a privacy officer, someone to own the issue, they don't work. And there are some of the older privacy laws don't require this, and I think they fail. I'm not going to mention specific laws, but there are laws that I think are really failing laws because no one implements them, and as a result, no one knows about them, and there's no one to actually do anything about them, and therefore, they might as well not even exist. Now, one thing that is, I think, really fascinating about privacy law, and also challenging about it, is it's like lava. It's really malleable, and it hasn't yet cooled. And this is something that I think is a little different than other fields of law, where the law is a lot more settled. I teach criminal law. It's another course I teach. Every semester, there'll be a new edition of the casebook, and I don't even have to look at it. Because pretty much the same thing, the pages shift a little bit. Every now and then they'll throw in a new case, but I don't need to check the elements of murder. Murder's the same. They don't change it. But privacy, on the other hand, I have a casebook on privacy, and every time I have to update my casebook, so I have to change like a gigantic amount of the book because so much changes, dramatic changes that affect fundamentally what privacy law does and is about. So there's a tremendous amount of change here. Everything is up for grabs. Could be that courts are coming out one way on certain cases. I think it's totally plausible. I tell my students, you can't go to a court and say, I think you should just change the elements of murder. But you can go to a court and say, you should look at this thing differently. You should take this very radically different interpretation, because everything is up for grabs in privacy, which is exciting, but also a little bit scary because the ground is so dynamic and isn't totally solid. But that, to me, is what makes privacy fascinating and fun, is that it does change so much. And it is evolving so quickly. And that, I think, is actually a wonderful thing. One direction that I've seen privacy develop in is that it's become more global. Privacy law is really global these days. It spans the world. I think roughly around 160 to 170 countries now have a comprehensive privacy law. And that's in addition to all sorts of other laws, sectoral laws, that address privacy in various countries. In the US, we don't have a comprehensive privacy law, but we have quite a lot of federal laws and state laws dealing with privacy. So there are just an enormous amount of laws everywhere. One thing that people will say is, oh my gosh, it's bewildering. Look at all these laws and they all conflict and this is just becoming a big mess. And that's partly true, but I also think what's underappreciated is that privacy law is actually harmonizing to a remarkable extent. We focus a lot on the differences, and I totally agree there's a lot of differences. but there's also similarities. What's also kind of interesting is that there are certain common things to the law. And if we look at what's common in the laws, there are actually a lot of common points. There is a lot of consensus on points. Definitely a lot of differences, but when we look at the fact that we have privacy law all around the world in all these different countries with different cultures, with different values, it's surprising how much common ground there is. So I think that's what's remarkable about it, is how much common ground it is. And also over time, I think we've seen privacy law grow together. I think it's moved to be more consistent with itself rather than grow apart. Certainly because we have so many laws and the laws have proliferated over time, there are more laws, and definitely that makes the differences pop out a little bit more. But I think also when you look at the general trend on the whole, I think we see that as new laws come about, they are drawing from existing laws. They are not radically different. Now, in the United States, I think the way that the U.S. law is characterized is very important, because the U.S. lacks a comprehensive privacy law, but I say sort of. It sort of has one, and that is the FTC Act, because in the void of a comprehensive law, the FTC in the United States has interpreted the FTC Act, which is a very broad act that says very broadly that there should not be unfair and deceptive trade practices. The FTC has interpreted that to protect privacy and security. And it's issued a series of cases. Ultimately, almost all of them have been resolved by consent decree. But there's a consistency in these cases, and each individual case addresses certain things. And if you look at the body of law, it's kind of like a common law, you start to see certain principles emerge from that body of law. And that starts to flesh out a lot more, what does protecting privacy mean? What are some of the things that are problematic activities? And this starts to, over time, has developed into, I think, a pretty robust set of things. And you look at that case law, I can see a lot of important things in that law that are in the statutory laws of other countries, in the comprehensive law. So we don't have a comprehensive law yet. There's always been talk in the United States of having one, and it seems that every year we hear about something almost there. We have one, we're going to have one this year, and then it doesn't happen. But we sort of already have something, and I think that's often underappreciated, is that there is this law, and a lot of the things that the FTC does are consistent with what other privacy laws do. Now, back to this theme of people and law. Governance and accountability are essential dimensions of privacy laws. That privacy laws need to have these things because they're very important. Without these things, privacy laws don't work, because they're not going to be self-executing, and when they don't require certain things to happen internally, that people have to own privacy, and there are a lot of internal things that must be done. Policies internally, training internally, a privacy program, doing impact assessments. All these things are key to privacy, and all these things occur internally. And you need to mandate a structure, at least some of the basic things that should be done, so that this issue is owned and that these activities take place. If they don't take place, it's really not going to work. You can have a law and it can say do this, and if nobody in the workforce knows about it and knows what to do, how is it going to get done? And I've seen this a lot. There are laws and no one gets trained in them, and as a result, now, how do you know what the rules are and what you're supposed to do with data? You don't. So it's really important that these governance provisions be in the law. I think that's really essential. But I think one of the things that privacy laws need to do, where they need to develop, is I don't think they go far enough right now. I think they need to increase the rigor and regulatory oversight of governance requirements. I think for a lot of times, unfortunately, a lot of the governance requirements are carried out in a mechanical way. Organizations, especially companies, are designed to be efficient. They create processes and they want to do things, and they want to do things in a way that is, standardized. They want to make things easy and quick and cheap. That's what they want. The challenge is that privacy is hard, it's complex, and it really doesn't work well when done in a mechanical way. And so we need to fight against that urge, that the fact that organizations are going to want to do this in that way, and force them to not do it in that way, which means to go slow, to exercise judgment, to really think about the issues. Not everything's going to be the same. So when you do an impact assessment, it doesn't just become a very kind of empty mechanical exercise, because that can readily happen where, a company can do all these things. They can have, impact assessments, and they can have policies, and they can have training, but it could be totally ineffective. You can do training and throw information at people, but that's not really teaching them. You can, create documents and shove them into drawers, and that's not, it'll look good. Someone comes in and says, hey, show me your stuff. And then, oh, look at this. We did this assessment here. Look at our policies. Look at all the stuff we have. It's not good enough. It has to actually be good. It has to work. And that's hard. That's hard work. It takes time. It takes thought. There aren't quick, easy answers to it. It really takes some judgment. And that's tricky. Because, organizations want certainty. They want clear, certain rules. Like, if we just tell us what to do, and they constantly, tell lawmakers, tell us what to do. Just tell us what to do, we'll do it. We don't like just kind of try to get it right, please. And they want to know, if we do this, we want to be safe. And I actually think, no, you shouldn't be safe. You should never be safe. People aren't safe. People are constantly at risk with how their data is being used. Why should the organizations that use the data be safe? They shouldn't be safe either. This is a risky activity in a very changing world with a very complex issue. Data protection should not be safe for organizations. They should worry about, oh my gosh, what if the rules change? What if things are different? What if we're enforced against and they say this isn't good enough? Yes, we checked the boxes, but it's very important to look at the quality of what's done. And if that's not done, then you just get a kind of mechanistic activity that is hollow. And I think it's very important that the law, I think, and enforcers don't want to really say, okay, you need more than just a training program, you need a good training program. You need more than just a data protection impact assessment, you need a really good one. And we're going to hold you accountable if we don't think it's good. We're going to measure not just whether you have it, but we're going to look at quality. And that's tricky, because that is a judgment call. It's less certain, but I think that's the ball game. And it's very important. And a lot of what happens in privacy, a lot of privacy protection is about what goes on internally. It's unseen. And a big factor of what's unseen about privacy is that a lot of privacy is regulated by contracts that no one really sees. So the consumer doesn't see these agreements. but they play a very big role in how privacy is protected in organizations. Because for organizations, a lot of large organizations will have their data, and they need to have a number of other organizations do things with the data. And so they'll have a lot of subcontractors who are getting this data and doing stuff with it. And they'll have contracts with those organizations about how they should be using that data. These contracts are really important. They protect people's privacy in a pretty dramatic way. What the contracts say, how the particular vendors that are using data are selected, the due diligence in selecting them, and also how the contracts are overseen. Are they in fact doing what they've promised to do in the contract? All these things are really key to how privacy is going to be protected. And this is just one example of the kind of internal infrastructure that is done through people and agreements and governance and architecture that governs and protects privacy. So it's very important that this be done well and this be done right. Another thing that I think is really important is that enforcement power should follow the data. When you have enforcement by a privacy law, it's not enough just to enforce against the companies that get the data have the data in the first place. I think the more effective laws regulate the data as it transfers over to different holders of the data. So I think good laws will, no matter who has if you get the data, you're covered, you're subject to that law. The law travels with the data. The enforcement travels with the data. When you have a law with the enforcement not traveling with the data, that's where you run into all sorts of problems. Because the minute the data goes outside the hands of the initial organization that has collected it and that has it, it loses protection. And that becomes a big problem. I think one of the most essential things that privacy law can do is require data minimization. And in fact, a lot of privacy laws do this. And they typically do this with a principle that says, minimize data. And that's a lot of times all that they do. This is another example of how something is hollow unless it's done well. Because I'll look at a lot of the laws and they all say the right thing, minimize data. And organizations will say, data minimization. And everyone says data minimization, but they're collecting and using tons of data and no one's minimizing. It's tricky because data minimization isn't like an easy thing where it's just a simple thing and it's very clear what that means. It's hard. It's very hard. But if it's not enforced rigorously, if it's not internally treated with rigor, more than just said, but actually carried out in practice in a meaningful way, it's meaningless. And I think that a lot of the things in privacy laws are like this. They'll say things, and you read the law, and it sounds great. But then in practice, it winds up not amounting to much. And this comes back to people. People need to enforce the law much more rigorously. People need to carry out the law more rigorously. The quality of what they do really matters. Takes a principle that would otherwise be hollow and gives it heft. Ultimately, privacy is about power, I think. That's what really privacy boils down to. And I think that to be effective, regulation must focus on power and structure and accountability. That's how we're going to make headway on privacy, the most headway. And to do that, you need people, but you need also a lot more rigor than what we are seeing now. So this is where I think privacy law needs to go. Because ultimately, we're in the early days of privacy regulation. People might think, oh my gosh, look at all the regulation out there. We have all these laws sweeping over the world. But I think this is actually early, not late. So I kind of say we're in the Middle Ages. We haven't even hit the Renaissance yet. Even though we're seeing all sorts of privacy law we're still not in the Renaissance. So there's a long way to go. I think actually a lot of the approaches in privacy laws are ones that I think are well-meaning, but I think ultimately are not going to work. I won't go into all that, but generally in my current writing and research, I'm looking systematically at different components of privacy laws, and for a lot of them, my conclusion is it sounds good, but actually it doesn't actually work, and it's not workable. And I kind of try to look at the future as like a chess match to say, okay, is there a way to make it work? And some of them actually don't think there is. So I think privacy law does have a long way to go. I think we need some new approaches. But I think generally what works, though, and what's key and what's really important is that nothing is going to happen without people. Nothing is going to happen without good judgment and people who actually care and are trying to do something in a quality way. And a law can be the best sounding in the world. It can say all these great things, but ultimately, at the end of the day, be very hollow. And so that's one thing I've learned, that law must encourage people to really take this seriously and do this. The enforcement must focus on that and really mandate that and create the right accountability for it. It has to do a lot more than just saying the right thing. It has to do the right thing. All this is really key for privacy law to work in the future. And that's where I think we need to go with privacy law. We've come a long way. We've really come far in privacy law. But we still have, I think, a long way to travel. But the only way that we're going to make headway, I think, is by focusing a lot more on, the people involved in using judgment, because just the language in a privacy law, the various mandated requirements, that's not enough. That's not enough. You need to make sure that they're actually carried out well and that they're enforced in a way that's really going to ensure that they're carried out in a really good way. And that's the end of my comments, and I'm happy to take any questions if anyone has them.
Let me ask a couple, and then maybe we can hopefully encourage some of the audience here as well as some of the online participants. We do have a few questions. But Dan, one of the things I think is that the complexity of all these laws gives some suggestion to the idea that perhaps we kind of need almost a global framework around privacy, right? Do you think that's plausible? And also, how can we simplify for the individual some of these laws? Because, when people go on and register on a site, for example, and you have to scroll through the whole page of stuff, most people don't read it. They just go to the end and say agree. And a lot of that has to do with the fact that companies are using this to cover every base. So any thoughts on that?
Yeah, well, you have two questions, the individual and how they can manage privacy, and also, a global framework. I think the framework is developing. I think that's still going to develop over time. I would like to see something, but I don't think we're quite ready yet, because I think that the law needs to develop a little bit more before we actually figure out, well, what exactly should that framework look like? Because I think it should look a little different than where privacy law is now. I definitely think that privacy law still has to grow. So I'm not ready to kind of set it in stone just yet. And I think it's good that we have a lot of experimentation and different laws and trying different things. I think that's great when we're in the early days of privacy and we don't know all the answers. I don't know all the answers. On the managing people's privacy point, I've written a lot about this. And the problem, I've actually critiqued privacy laws for over-relying on privacy rights. So a lot of laws give people rights and privacy. Here's the right to access your information. You can find out what information they have. You can opt in or opt out of different things. Check this box if you want this. You can ask your data to be deleted and all these other rights. And I don't want to say the rights are bad, because I think they're fine. But I think the problem is that a lot of laws over-rely on rights, and they think, if we just give people these rights, privacy is protected. I actually think in most cases people really can't exercise their privacy rights. It's not really possible to do it, because a bunch of things. One, it doesn't scale. You know, it's one thing for one company, but there are thousands of companies with personal data, companies that even the ones I know about I don't have time to deal with, let alone all the ones I don't know about. And I'm supposed to, read all their policies and then figure out what's going on, which is going to be really impossible from the policies. Then I have to make all these decisions about this, and I have the right to correct my data. So what am I supposed to do? Look at every organization that has my data and proofread their records for them? Oh, and by the way, they get new data about me every day. So I have to do that every day? How am I going to know when data is no longer necessary and it should be deleted? I don't know. And I'm supposed to keep tabs on all this? How am I to know, and then how am I to really know the risks involved with my privacy? I don't know, and I'm an expert. But if someone asks me, okay, what's the risk of using this device and giving data to this company? I would say, okay, I need a week to hang out and talk to your privacy officer, because I want to know who's your team and what are they doing. If you say you have good security, well, I'm supposed to take your word for it? No, I want to see. I want to go behind the scenes, open up the hood. How good is your security? Do you have pen testing? Do you have good training? Do you have good privacy training? I want to know a lot of details. I want to see your vendor agreements. Who are your vendors? How good is your due diligence? Who's all getting the data? And let me see those agreements. I want to review them all. And then what about algorithms and analyzing the data? I want to understand what decisions are going to be made about me based on my data. Well, you can show me the algorithms and show me the logic, but that's not good enough. If algorithms are trained on data and they're machine learning and they are evolving as more data is fed into them, then I need to see all the data that's being fed into the algorithm. But it's constant. So actually hook me up to your computer system so I can see your algorithm in real time. And also I need some computer scientists to help me understand all this, so then I can actually figure out how the algorithm's learning, how it's evolving, and then ultimately what it's going to decide. And I need to know everybody else's data. The bottom line, it's impossible. It's an impossible task for the individual to manage. And I don't think it's plausible for individuals to manage that. When people go into the supermarket, they don't have to, okay, let me see. Okay, here's milk. Let me research the farm that the milk came from and see if this milk is safe. No, we know that the milk is going to be safe. Someone has figured this out and is mandating safety on the milk, and I can buy different brands, and I know there's basic safety to that milk. I don't have to worry about that. And I think that's really what needs to happen in privacy. I don't think the average consumer, or even an expert, quite honestly, can make these determinations based on the knowledge that they're given. And I don't think they can ever get to that knowledge. So I think self-management, while it's nice in certain cases, yes, if there's a company, and yes, I know there's a record that they have, and I really don't want them to have it, then great. I should have a right to have them delete it if they don't really need it. But beyond that, I don't think that that's the way that we really protect privacy. We can't put it on the shoulders of individuals and expect them to somehow figure this all out. And that's unfortunately what a lot of laws do too much of the time.
Thank you, Dan. Let me see who in the room are on.
Morning, and thank you, Daniel. A very interesting presentation. My question is, I get it, privacy is not dead, right? But every day you open the newspapers, you see data breaches. So the numbers of, my personal data out there continues to grow. We all download Instagram, TikTok, or whatever social media new app is out there, and we put our pictures, and even those among us that are worried about privacy, we even do it ourselves, right? So the question is it enough to catch up? And if individuals don't take it seriously, would it ever even work? So just a thought on that. Thank you.
Well, the law is always going to be, the law reacts, and the law, is always going to be, trying to catch up. But I do think that if you put into place, at the end of the day, a lot of privacy, technology has always evolved. Technology constantly changes. But what doesn't change are a lot of the basic problems, which they boil down to, lack of accountability, bad incentives, improper uses of power over people. These are human things. These are things that have been with us forever. And you boil it down to those problems and the wrongs that occur, they are, they're not evolving. Now, the technology is evolving and the capabilities to do these things evolve. But basically, I think one thing we've learned is that, the more you hold people and companies and organizations accountable, the better off we're going to be. And I think the law often doesn't hold them accountable enough. The more you force them to internalize their costs and not slough them off to individuals, data breach is an example. They aren't fully internalizing their cost. The incentives aren't right. I think we're not going about things right on data breach. There are ways to address it. I think we can definitely improve how we handle data breach. I even wrote a whole book on this. A lot of the law goes after the organizations that are breached and really pummels them. And I think there's only so much marginal benefit you can to pummeling them, so you can raise the fines a little bit more, and you can, paddle them a little bit more when they have a breach. But and they've all done something that they could have done better, and I think we can improve that. But there are a lot of other actors that contribute to the problem that are not held accountable at all. Makers of buggy software that could be better and less vulnerable. Other players that miseducate people all the time. People are being educated to fall for phishing schemes. We have a system where, it's up to the consumer to somehow figure out if an email is legitimate or if a website is legitimate. A lot of attention is done to authenticate me as a consumer to an organization. So they'll want to make sure I am, who I say I am. But what about them authenticating themselves to me? I don't know how many times I get an email that I can't tell if it's a legitimate email or a phishing email, and I actually, it's from a legitimate company. But they'll send these emails that look just like a phishing email. How am I supposed to know? We're told, for instance, the law says you can unsubscribe to email, and you have to have an unsubscribe link. So you get a mass email, it's an unsubscribe link. And it says safe unsubscribe. So, it's safe, I click it. I'm supposed to click that. Well, that could be a virus. Like if I'm a hacker, I just put safe next to it, unsubscribe, and there you go. This is the problem. We're taught the wrong thing. So there's all these things that we can do to improve accountability. I mean, we'll never get to perfection because there's always a risk. There's risk in everything. And if you really want to you reduce the risk of a data breach to zero, then, don't use data, don't use the internet. But we're not going to do that. So there is this trade-off. But we can do better about the risk. And I think we can be a lot better about privacy. But we have to do the right things. We'll never be perfect, and technology will always present new challenges. But I think if we keep our focus on the right things, which are incentives and structure and power and governance and these things, we can grab the bull by the horns a little bit more, and I think be able to not be kind of overwhelmed by the dizzying pace of technological change.
Dan, one final question from Laura Dawson, who is on World Bank Live. How do privacy regulations deal with the bias of values of those making decisions about what is good and right? We can each look at a behavior or action and come up with a different point of view of its value on business and economies.
That's a great question, and it's a really tough question because I don't think it's possible to create neutral laws. Laws must make a judgment, and we see this in free speech. Oh, the government should be totally neutral as to any message. I don't think we can be neutral. I mean, it's a great ideal. It's great in theory to say there's, this position of neutrality where no matter what your values are, that the law will kind of let them all be equal and flourish. But I think ultimately choices have to be made. Value choices need to be made. And that will mean that some people will lose. Some people who think, that they see a different worldview, their worldview will, the law has to make a choice. The law has to make, some companies say, look, in a world, we want all this information sharing, and what really matters is, profit and efficiency, and any kind of restraint on our data is going to have an impact on that, and that's not worth it. I think we need to say, the law needs to say, no, we don't agree, and that's a hard choice, because I don't think, I think there's some merit to some of the other interests on the other side. So I don't think protect privacy above all else, but I think it's important that we have to make some choices. And I think the law needs to make hard choices. I think the law can still be flexible, but at the same time, I don't think the law can be perfectly neutral. And there are going to be some things where the law is going to say no. And, some people with different views are going to ultimately be told, sorry.
Thank you so much, Dan, for such an engaging session. We'll now take a short break to set up for our first panel event, which is on the very interesting issue of emerging issues in algorithms, AI, and data analytics. Please come back in 10 minutes, roughly about 10:10. For those of you online or in person, there are some supplementary materials outside, and these are like video messages from UK Information Commissioner John Edwards and Mark Rottenberg, the president of the Center for AI and Digital Policy. So please come back in 10 minutes. Thank you.
Kia ora koutou katoa, as we say back home in New Zealand. Thank you for inviting me to speak to you as the UK Information Commissioner. I'm glad to be able to contribute to the World Bank Data Privacy Day, albeit through a screen. My engagement with you has come full circle in some ways. I remember speaking to you all back in 2021 in my previous role as New Zealand's Privacy Commissioner. There, I was deeply involved in conversations about data protection and privacy with colleagues in the Asia Pacific and beyond, recognising the need to build global networks in that corner of the world. When I was new in that role in 2014, I chaired what is now called the Global Privacy Assembly, and getting the agreement of over 100 data protection authorities to adopt resolutions is no mean feat. In 2021, you also heard from my esteemed predecessor and good friend Elizabeth Denham, who spoke about the importance of global standards when she was the chair of the Global Privacy Assembly. And here I am, as UK Information Commissioner 1 year in, adjusting to life here in the UK, tea, multiple Prime Ministers, politeness, and continuous news about the royal family. But what I want to touch on today is the importance of international cooperation and networks when it comes to raising data protection and privacy standards and adapting to new technologies. At the heart of all this is people. We need to continue working together and making the case for data protection and privacy while realising the benefits of technology, especially for some of the most vulnerable people in the world. You, at the World Bank, have a unique perspective and role to play in raising standards and data protection principles. You cover a range of jurisdictions. You see and recognise the important role that data protection plays in building trust and confidence in economic life, and can promote those practices across the economies you work in. That's why I was so pleased to see your Chief Privacy Officer, Tammy Dokken, at the Global Privacy Assembly last October in Istanbul. She was talking about data protection in the context of international humanitarian aid and crises. Data Protection Day, or Data Privacy Day as we call it in the UK, is a celebration of the hard work that goes into keeping people's personal information safe. It's a real team effort. It's no longer a niche role relegated to a dusty back room. It's the lifeblood of a successful business. It's what builds trust and confidence between an organisation and its customers, and it's what drives innovation. We're starting to see an appreciation for the importance of privacy across the board, understanding not only what the law says, but what it means in practice. The trick is making data protection as easy as possible for organisations to comply with. And good practice in one part of the world can raise standards for all. Take the UK's world-leading Children's Code, which has been replicated in California. It sets minimum design standards for online services that children can access and has improved the online experience for children everywhere. Whether they're in Manchester, Myanmar or Mozambique, children should be afforded the same standard of protection when they're online. We also need to think of our most vulnerable communities. World events have squeezed many household finances, and organisations may be increasingly likely to consider offers of technological solutions to improve community outcomes, tackle societal challenges, and drive efficiencies. We must not lose sight of the groups of people who need the support of privacy law, but who are simply not aware of the rights they have in their jurisdictions. That could be people on the move, dealing with the administrative complexity of seeking safe refuge. This could be travelling communities or the digitally excluded. How can the law protect them, the law we all put so much energy into protecting, if those people don't know the law exists? We are trying to play a role here. How can the privacy community, which includes you, better reach these communities of unmet need? That's my time just about up. I don't want to keep you from the rest of this fascinating agenda which the World Bank Group have pulled together for you today. I hope you all enjoy the rest of the event. Happy Data Protection Day.
Hello, my name is Mark Rotenberg. I am president of the Center for AI and Digital Policy. It is my pleasure to be with you today at the World Bank to celebrate Data Privacy Day 2023. This is a very important date. It recognizes the moment when the Council of Europe announced the new Privacy Convention and created the opportunity for countries to endorse the first global convention for privacy and data protection. I want to thank the World Bank and other international organizations for the work that they do in support of data privacy. It is vitally important to ensure the protection of personal information, particularly in this age when we are all so dependent on how systems make decisions about each one of us. I'm going to say a few words about the relationship between data privacy and artificial intelligence. Many of us know this year that artificial intelligence is one of the big topics in the data privacy field. In fact, some of us may even be writing our essays with the assistance of such new generative AI techniques as ChatGPT. For those in the data privacy field, the challenges ahead will in part look familiar. For many years, we've talked about the importance of fairness and accuracy and transparency in the processing of personal data about individuals. Those three goals continue to be important as AI techniques are deployed in businesses and organizations to make decisions about people, but we also need to consider the new challenges that AI creates.
A lot of the personal data that's being gathered now is being used in the context of machine learning, and this produces outcomes with a high degree of statistical accuracy. But it's often very difficult to prove the basis of an outcome. For example, a credit determination, an employment determination, even criminal sentencing. More and more of these decisions have become subject to black box systems. And it's important for those reasons that we ensure systems of transparency and explainability and independent assessment to ensure that the decisions that are being made about people are fair and are accurate. We also need to consider the ways in which AI techniques are being used to manage systems for communications and transportation that might implicate public safety. And here I think data protection also provides some guidance. We know the importance of independent assessments, routine reporting, and also public accountability so that government officials are able to assess the reliability of these new techniques. Looking at the year ahead, I'm sure we're going to have many new challenges with AI. Stay tuned for the release of GPT-4, but also keep in mind that the challenges ahead and the answers we pursue may find some of the best solutions in our common traditions of data protection, which we celebrate today. Thank you.
Well, thank you all for coming back. And so we have a really, really interesting session, I think. Some of you know already that the use of some of these emerging technologies and complex algorithms in the last few years has caused the scale of personal data collection and processing to grow exponentially. I said that in my opening remarks, and I think Dan also mentioned that. So while these digital leaps hold a lot of promise, right, we all want to adopt some of these new technologies. There's also a little bit of lack of clarity about how all of this data is processed in the background and how it's going to be used. And so I think this next subject, which is really a panel on discussing some of the emerging issues around algorithms, data, and analytics, is super interesting. And to talk more about the subject, I'm going to ask Dan again to lead a panel discussion. Sorry, Dan, you have a bit of work today. Of course, please do jot down any questions that you have, and we'll find some time to ask those questions also of the panel. So Dan, over to you.
So I'm really thrilled that we have two wonderful speakers here today to discuss these great issues, these really challenging issues. I'd like just to briefly introduce them. Alvaro Bedoya is a commissioner of the FTC, and that's his current role. Previously, he was the founder and director of the Center of Privacy and Technology at Georgetown University Law Center. And then before that, he served as first chief counsel to the Senate Judiciary Subcommittee on Privacy, Technology, and Law. And then we have Brenda Leong, a partner at B&H AI, which is a boutique law firm uniquely founded by a partnership between lawyers and data scientists focusing on AI governance. And she was previously senior counsel and director of AI and ethics at the Future of Privacy Forum. So welcome to both of you. Thanks so much for coming out here today and joining us. And so I'd like to have a conversation with you about AI algorithms. And I think I'd like to start just a little generally and get your thoughts on just some of the emerging problems that are that you see that need to be addressed on these issues. And we'll start drilling down into some of them. But I'm just curious that if you look broadly, what are some of the things that most concern you, that you think are the things we really need to focus on as a society to address these things?
Sure. Thank you, Dan. And let me say it's a pleasure to be here with you and Brenda. Let me quickly say two things that I spend a lot of time thinking about. The first is I would describe, I think, as a social problem as to how people understand algorithms. And maybe the best word for it is a fallacy. And I hear it, and I'm sure both of you do all the time. I hear it all the time. And I hear it from remarkably informed people. And it's this. It's this idea that because a technology is new, that it is therefore unregulated. I think there's a lot of this when companies, when you hear companies scramble to describe themselves as tech companies and just sort of picking random made-up companies out of a hat. There'll be, a dog walking company that says, oh, we're not a dog walking company, we're a tech company. We're not a diaper company, we're a tech company. And I'm sure, confident all of you have heard it. And part of this is marketing. Part of it's smart marketing, right? You want to tell people your product is new, you're doing something different. Maybe you are, that's great. But part of it is also a way of saying, oh, those old laws, those don't really apply to us because we're a tech company, right? We're different, we're new. And I think that can be risky. And I think that can create a misimpression around what the law is and what it does. And to speak very concretely, the core authority we have at the Federal Trade Commission, and For those in the room that aren't familiar with us, we have really a dual mission. One is to protect competition, so we have this Antitrust Competition Authority and this Consumer Protection Authority. And of course, they're related and intertwined. Our core authority is a law called Section 5, which originally barred unfair methods of competition in 1914, and then 1938 was expanded to bar unfair and deceptive trade practices. And the very interesting thing I will hear people say is, oh, well, does Section 5 apply to algorithms? And I think the best way to think about Section 5 is that when Congress passed Section 5, with only a few exceptions, they very deliberately did not specify an industry. They very deliberately did not specify a sector. They said if you are deceiving people, if you are hurting them in a way they can't avoid and isn't outweighed by other benefits, that is illegal. And this commission has the authority to stop it. And so I want to say something a little tongue-in-cheek. I would encourage folks in the room and people listening at home or at work, anytime you hear what sounds like this profound pronouncement about algorithms, stick in a different word there, right? Something like documents, right? Does privacy law apply to documents, right? Does Section 5 apply to documents? And I think it'll help bring everyone closer to this idea that, like all other technology, it is subject to regulation and subject to law. So that prompts the natural question, and I'll touch on that and then shut up, about, okay, great, well, what do you want to focus on? You're a law enforcer, you're a regulator, what do you want to focus on? And I think that's a good question because it helps bring down to earth this lofty idea of algorithms. And for me, I don't particularly care that much. I don't spend that much time worrying about an algorithm that might, let's say I'm trying on glasses virtually, maybe put the glasses off at a slight distance than they normally would, or maybe I'm playing video games with my niece or nephew and it does something funky and it doesn't really work. I don't really worry about that much. What I worry about is the fact that increasingly automated systems, and by the way, when someone says algorithm, it could mean a truly advanced, neural network driven machine learning system, or it could mean a coded set of steps that means a specific thing that's pretty clear. But increasingly, automated systems are used or help make absolutely critical decisions about our lives. So whether you're going to get a certain apartment, the rent you might pay for that apartment, whether your resume will be read by someone who's looking to hire someone, whether you'll be hired, how you should do your job. And it's not just blue-collar jobs, it's increasingly more sophisticated jobs. Whether you should be fired, whether you should get that loan, what your credit should be. I think that we as law enforcers and regulators need to focus first on these systems that really affect people's daily lives, their bottom lines, their financial security, their physical safety, their health. I haven't even gotten into the healthcare algorithms and systems, but that is what I would focus on. And those are the two questions that I spend a lot of time thinking about, trying to dispel this myth of the new unregulated algorithm and trying to focus our energy in terms of understanding it and protecting consumers on algorithms that regulate really basic systems in our lives.
Thank you very much for the chance to be here today to the World Bank. Dan, to you. It's a pleasure to be here and discuss this. I'm going to sort of ditto everything that Alvaro just said in terms of this idea, and it leads into what my point was going to be, or is going to be, in terms of people's approach or thoughts about systems that are called AI or automated decision making. And so what I would say is we see a lot of challenge in the idea of transparency and context, is what I will call it, and expectations about these systems. So just as Alvaro very clearly pointed out, that these operate within an existing legal and regulatory structure. They aren't off in some new limbo of Wild West operations that aren't subject to the existing rules. By the same token, these systems are run by humans, built by humans, used as consumers, used by human consumers, and to do human tasks. And yet we seem to see this idea that people's expectations change drastically when they're told that an AI system is involved. And it can be in good ways and bad ways. And there are pros and cons to the application of machine learning systems in these new contexts. But in terms of our expectations, we know there's such a thing as machine bias and confirmation bias and those kinds of things, and yet we seem to continue to hold these systems up to this sort of level of expectation of perfection. When we talk about bias in the data or bias in the model or bias in the outcomes, it's as if there is an alternative that is not biased. It's as if there is this ideal perfect state of operations that we somehow thought the AI was going to get us to, and it didn't. When in fact, there is no perfect ideal of operations. The reason the data is biased and the model is biased is because humans are biased, and systems are biased, and cultures are biased, and countries are biased. And that is built into our existence and our infrastructure over millennium. And that is what is now being reflected in an automated sense. Now, the con is that we are maybe now embedding those biases in automated systems and scaling them. That is probably the single biggest risk and fear, is that we are taking these biases, sometimes unknowingly, encoding them into systems, and then applying that faster and farther and on very sensitive issues like healthcare or financial systems. And there's significant risk to that. The pro is that we can analyze that. We can break that down and look at it. We can look at the systems we've built. We can look at the coding steps. We can look at the outputs. We can do pattern analysis using these same kinds of technologies on the systems that we're using and try to evaluate them in ways that we may not ever have been able to do with human systems. You couldn't go back and look into a judge's brain or a regulator's mood or any other individual or group of individuals as part of a system and necessarily recreate what they were thinking, what factors influenced them, how they put out an output on a given day about a given person. We may be able to do that, at least to some degree, with these automated systems. So that's the pro, that's the benefit. And the scaling can also be a benefit, because we can operate at scale if we can make them more fair in a way that will benefit people who have previously not had either access to, opportunities within, or fair dealings from existing systems. So that's sort of the approach that we take to this, is that this is one more tool of technology, as Dan had in his opening remarks, ever since the telephone and a portable camera and any kind of computer at all. There have always been this fear of how it's going to change us, but at the end of the day, we are still all operating with each other in social and political and economic relationships, and we have to figure out how these automated systems can hopefully make some of that better, more efficient, but at the same time identify what risks they might be introducing and figure out how to mitigate for those.
I think I agree with everything. I think that one thing that, when it comes to discrimination, some of the things that AI can do that are troubling is that, I think you're right, the discrimination is in the data. The data is tainted with bias, and then the algorithms pick up on that bias. But when they do that, they do a couple things. One is, it can be hidden, so it's harder to see it. And obviously part of that's dispelling myths. So the fact that people think that an algorithm is somehow not biased and that the outputs of an algorithm are not going to be biased is problematic. So we definitely need to see that that's not true. And dispelling that myth, I think, will will give us some benefit. But there's also, it can be hard to find the bias. It can be hard to detect the bias. People are not very good at figuring out, bias in data. Now, algorithms might be able to help us, but we have to figure out then how do we train them to do that and figure out bias when the data that we're training them on is biased, and the bias sometimes is hidden. So we have to figure that out, and that's difficult. The other challenge I see too is the reification of bias. That when humans have bias, they make decisions, but not everyone is biased. Not every decision winds up being biased. But algorithms can take discrimination in the data and then consistently apply it in a more systematic way. And then we have systematic bias that is now kind of fully baked in. So that's a difficulty. But another thing that I also see, and I'm curious what your thoughts are on, is that new categories of discrimination can be had. So we can sort of ferret out and say, okay, this is discrimination on race or gender or religion and so on. But there might be new categories of discrimination that could either be related to that or proxies for it or even independent of it. Just systematically, people born in a particular year, just because of some reason, are systematically deemed by the algorithm to be less than or treated differently, or some other characteristic that we might not know, because we don't fully know what the algorithms might be doing or which things it might be using to make its decisions. So how do we address that problem of kind of existing categories of discrimination and trying to prevent that from becoming reified, screening that out, and then also new categories of discrimination based on things that we might not even realize are being used to discriminate. And do we want discrimination because of something that you're not even aware of is being used? Height or weight or some other, the color that I put on my shirt, the black shirts are now discriminated against, or something that we'd say is not appropriate to be used as a kind of systematic way to make decisions about people. But ultimately, algorithms are going to have to use something, right? They're going to use something to make these decisions.
I think that really is the million-dollar question, and very much what my firm and many of the people that we work with are striving to do, which is to figure out ways to audit and monitor these systems, which ties back into what I was saying, is that one of the opportunities is that we can audit and monitor them. And we can audit and monitor other systems too. I realize that didn't just burst into being 5 years ago, but we can do it in a very coordinated way over time and over a particular model and its operations. We can look at if you change the data structures that you are using, the data map, as it might be called, the different fields that go into the model at the beginning, and say you take one of those fields out, how does that change the outcomes? We can look at the outcomes themselves and do analysis of that. And this is, again, something that we literally do every day at my firm, is take a particular model that a company's running, and it can be doing anything. It could be projecting insurance risk. It could be looking at patient management, errors in patient management in a hospital system. It could be looking at credit scoring. It could be looking at, customer targeting for retail operations. I mean, these models can be designed to do pattern analysis on data to project recommendations and outputs on, an almost unlimited set of particular applications or problems. But in every single case, you can then go in and look at the outcomes themselves and do an analysis. And this is why my firm is a partnership between lawyers and computer scientists, because we write the literal code to do the testing of the outputs to evaluate. Now, is that perfect? And is that going to find every single option or possibility? No, of course not. But it can certainly look for the known quantities like protected classes, which is, as a law firm, we're interested in helping our clients comply with the existing laws for anti-discrimination classes. And so we can look at that, and then we can test for other things. We can say we're concerned that maybe there are regional implications or there are some other type of implications. And we want to test and see if that, and if we can think of the target and create the category, then there are usually ways to identify and analyze for that, and then try to figure out if it's impacting the outcomes in a way that is not desired, whether it's illegal or not, if it's unfair or if it's just not even a good business outcome, what can we do about that, and how do we adjust the model for that?
One thing that I love is the complexity of this, and the little details that I think illuminate the challenges that companies face, and with the help of folks like Brenda and others, I think are increasingly trying to meet and address. So to your point about new kinds of discrimination, what I think is really interesting is oftentimes when you look at the kinds of discrimination we're accustomed to and understand, when you start digging in, you realize that it's not actually is the wrong word, because it suggests that it's in opposition to the discrimination, but it's related or partially caused by a panoply of very specific things that don't necessarily on their face have to do with, say, gender, but are associated with gender. So what the heck am I talking about? We spent years together with Claire Garvey and Jonathan Frankel when I was at Georgetown, looking at face recognition systems. And so one of the historical issues with these systems, and in fairness, a lot of the companies are starting to close these gaps, but historically the systems underperformed when trying to identify women's faces. And so that's interesting. What's that about? So we spoke to some engineers, and they said, and it's not about XX or XY chromosomes, right? It turned out that their best theory was that women are more likely to wear cosmetics, right? And the purpose of cosmetics is to eliminate blemishes, right? Eliminate data, right, that the algorithm can use to differentiate faces, right? Another one was that women were more likely to have longer hair that hid a greater portion of their faces than men. So again, less data, less ability for the algorithm to differentiate on the basis of, ears or forehead or whatever this area of your face is called. And so even within the discrimination that all of us would recognize, it's often caused by a panoply of specific factors underneath it that are related to gender, but that don't necessarily have to do with, gender as gender. So you said also something interesting, Dan, that I want to live in the complexity of for a beat or two, which is the biases in the data. And what's really interesting is that this in and of itself is very complex, because, people might immediately hear it's in the data and think, oh, it's in the values, the different values of the data. So let's say I have a graduate school of some sort. I want an algorithm to help me sort candidates so that my limited number of readers can focus on the best candidates or the people on the fence. And so I might say, take a look at my old data to see who I've admitted in the past, and help me, call my stack of applications. And so if the bias is in the values of the data, it may be that this medical school has historically rejected female applicants at a greater rate than male applicants, right? So that means that there's more no's than yeses for women than there is for men. Okay, right? But it might also be that there is no data for the female applicants, right? So it might have been that historically the institutions simply didn't admit women, and so the historical data has a big nothing for data of women, right? And so when someone presents an application and it has, say, oh, I was part of the, Women's Leadership Council, or a set of activities that are predominantly populated by women, the system may not simply weight that in any way, because there have been no successful candidates that have had that information in their application, right? So it's one thing to have differential values. It's another thing to have data that just doesn't exist, right? That also confuses the system. And then finally, it could be, not finally, because there's actually many other dimensions to this, it could also be variances in the quality of the data, let alone the structure. I won't even get into the structure. But one thing we noticed with the face recognition systems was they'd be built in a lab, right, as it were, like a computer somewhere. And they'd be tested on, passport photos, or maybe if things are a little crazy, this known data set of in the wild photographs, right, of people just existing in the world. But then they'd be deployed in the field, and certain locations would say, this thing doesn't work. It's consistently misfiring. It consistently doesn't do anything we want it to do. And then you look at the input, and it would be grainy surveillance footage from surveillance cameras they've had for 2 decades or a decade and a half, right? Whereas certain sites that tend to be wealthier, more affluent, have a different population of people coursing through them, said, oh, this thing's great, right? And in those instances, they'd have more sophisticated surveillance systems that would be eye level, that would be high definition, et cetera. And so there, it's not necessarily even about the values, it's about the quality of the information being fed into the system being different from that in which it was developed. And so, yeah, and so how do you get at this? I am, over the years, and this is not some big revelation, this is thanks to the work of a lot of our peers and folks in the field, I'm increasingly skeptical of transparency around algorithms, let's see the code, and much more interested in outputs and inputs and seeing patterns there and seeing different performance there, particularly with respect to outputs, but often the inputs will illuminate. Oftentimes with respect to transparency, a lot of these systems, I mean, all of you have heard it before, sometimes the designers themselves don't know why it did a particular thing. And so explainability for me isn't some holy grail or something that is going to be terribly, is as important as just looking at the outputs and seeing how they fall across different demographics.
I think this is a great segue into my next question, which is, who should evaluate algorithms? How should that be done? Should the algorithms be made available to the public so people can look at that? But then the challenge is, how do you make all the data available to the public? Because I think, as you rightly mentioned, just the algorithm alone is not enough. If we're evaluating outputs, who should evaluate the outputs? Should it be the organizations tasked with doing that? Should enforcers look at the outputs? How should this evaluation be done, and who should be tasked to do it? Should organizations be trusted to kind of police their own algorithms, or should the FTC, everyone submit, constantly be monitoring outputs? And then for what?
I can kick us off. That I was getting at earlier of this idea that they're not regulated, and so let's divide the question into the process of evaluation and should people submit, should they not submit, et cetera. Let's set that to the side for a second and ask. And I'd like to dwell on the more basic question of who should evaluate the algorithms. And I, think that this is an answered question in the sense that, the EEOC, the Equal Employment Opportunity Commission, has certain jurisdiction about hiring and employment discrimination. And so in the same way that they regulate, employment documents, right, they regulate employment algorithms, or they should if they haven't yet. The CFPB has certain authority around financial products, right? And so if an algorithm is being used to generate a particular financial product, I think the best way to say it is that there is no algorithmic exception to federal or state law, right? Just because something is done in a particular way doesn't mean that the subject matter regulator doesn't have jurisdiction over it. And for the Federal Trade Commission, we have this broad authority under Section 5, but if you're out there telling people your algorithm is, 100% accurate in every setting, tried and true, that is a representation that is not exempt from enforcement, as would my telling you that, this face cream is going to clear up your eczema, 100% of the time, right? Or add this to your, I was going to try to make an automotive metaphor, but I know nothing about cars, so I will stop there. But I think that, so I think the subject matter question is an answered question. The much more interesting question is, should there be an obligation in certain settings for companies to self-test, for companies to submit to a regulator? That is an open question. And we have a process right now, an ANPR, which is the stage before we propose a rule, where we're asking the public, where we have asked the public to comment on, in part, on what should be the rules for certain systems, automated systems, when they deal with these big picture issues or these serious issues around housing, healthcare, hiring, et cetera. And that's something that we're trying to think through with the help of the public, along with many of our other peer agencies and enforcers.
I can definitely understand why a regulator would start with the regulators should be regulating the companies, and I don't disagree. But I do agree that, in a sense, that question is answered with the precedent that we have of regulated industries or even just general economic practice and expectations, which is that it's all of those. The companies don't wait for the FTC to come in and tell them if what they're doing is okay. They do what they think is okay or what prior companies have been done, that's been found to be okay, and they monitor that internally, and they try to do, assigning good faith to all actors. They try to do that responsibly in a way that's going to be sufficient if the FTC comes calling. They also probably hire external auditors. We know in the financial services industry that's required in many contexts, in many cases, and many companies might do that anyway as a way of checking their own internal monitoring and auditing. For whatever the particular standards are, and making sure that they have an external set of eyes reviewing what they're doing in their day-to-day governance to make sure that it meets whatever the standards are. And then, of course, there is either law or regulation to be sort of the top-level enforcement and set the playing field for the commonality of expectations for the consumers broadly. I think the not bigger challenge, but I think the challenge of that is, what are those expectations and standards? What should they be? What are they auditing for? When a company does its internal governance of its AI system, what should they decide is fair, that is going to be considered fair for either their own business purposes or for legal compliance purposes or for FTC regulatory purposes or for public relations purposes, that it meets that. And I think that's that's where we're in a period of a great deal of flux, is trying to figure out to what level are we monitoring for what are those standards going to be. And obviously the answer is going to be different for different industries. It's going to be different for different levels of risk based on what the systems are being used for, how much personal data is involved. Does it impact people individually, or does it impact groups, or does it impact other businesses? And then that's the final sort of complexity of it, to use the sort of theme word here, is that there's always going to be multiple players in this. Very, very few companies actually build and develop the AI systems and use and operate them and do it in a consumer or customer-facing way. Usually there's 2 or 3 or more companies in that relationship of who developed it, what business operates it, and who has the consumer-facing piece of it. And to what extent is each of those responsible for the auditing and the oversight, to what standard, and when there are problems, who is responsible for either punitive action in terms of fines or other outcomes, or responsible to fix it. And I have a lot of thoughts on all of that, but those are the questions that I think that we're trying to answer now.
It's in the news a lot. Yes, so let's take your question.
Well, thank you, Professor. So, Mario from the Data Privacy Office of the World Bank. It's just a sort of follow-up question on who should enforce or who should monitor and regulate algorithms. So I think Professor Bedoya mentioned that there are different regulators, even within the US, that have mandate over some pieces of, let's say, the risks associated to algorithm and artificial intelligence in general. My question is whether that model of having different, let's say, enforcers trying to coordinate among themselves let's say, the monitoring supervision of AI and algorithms would be the best model, whether we should go for something like the Netherlands just adopted a sort of regulator for AI issues, which will have a sort of role of coordinator among different data and competition authorities. So I think that's my take, because I think it's really tough to have different regulators, someone needing to take the leads and decide who will be the one to take, let's say, the final approach in terms of how to proceed and monitor those activities. Thank you.
So I think this is a great and urgent question, and I have a clear point of view on it. I have no opinion of the system in the Netherlands. I'm not familiar with it, and so this is I don't know the contours of it. So this is not a comment about their system. But here's the thing. 2023, each of us are going to use, Lord knows how many algorithms today in your regular working day and when you get home, right? I open up my email, and the emails that I see are driven in part by algorithms. I drove to work or drove to this panel, and an algorithm helped me find my way here, right? I check my social media, and an algorithm is making those decisions. And those are just, that's just, what is it, 10:15, right? Or 10:50, right? And so I cannot stress enough that if you create a regulator to regulate algorithms, you are creating a regulator that in fairly short amount of time will regulate everything. And unfortunately, I fear that it will be populated by, look, I come from the world of tech policy. I love the people in the world of tech policy. They're wonderful, right? They're creative, interesting, etc. But, a lot of our folks don't have, for example, deep expertise in the decades of precedent in American civil rights law, right? There is a body of law around discrimination, right? It's slightly and subtly different in housing versus education versus employment. And for me, the real risk is that you create this idea that this new thing isn't subject to the old rules. Because I think I think if anything, we need those old rules more than anything because of this false perception among certain industry actors that, we can do whatever we want because it's new. Who knows what will happen? This is exciting. We can do whatever we want. And so for me, I think the challenge is taking the people that might populate an agency like that and making sure they see the excitement and see the urgency of them going to work for a Department of Education. Speaking in the American context, of course, the Department of Education or Federal Trade Commission or the EEOC, the Equal Employment Opportunity Commission. That, I think, is the challenge. So is there a need? Absolutely. Is there a problem? Absolutely. Should we create something totally new that is rife with this fiction that we're confronting a completely new set of problems? I worry about that profoundly.
Yeah, thanks, Alvaro. Great discussion. So following up on that, are you suggesting that it's better for everyone who is doing AI to kind of self-regulate, maybe go to B&H and conduct a 360? But the problem is that if my company does AI and we think with our scientists, we think we've done a 360, but we've actually done a 120. Because we're limited by the perspective that we see, which is what creates the bias most of the time. Because garbage in, garbage out, you put in the information based on what you know or the data that you have, but the data you have is incomplete. So I can go to 3 different agencies and I still don't have a 360. So if you go to the agency that Mario was talking about, they're specialized in trying to look at all of the corners. They may not see everything either. But I think that's a little bit better than waiting for a reactionary check when someone complains to FTC under Section 5, and then FTC starts looking at it, but then the thing has already been promulgated. It's propagated all over the place. So FTC now says, well, that looks like false and deceptive advertising. So you got to stop. Or they go to the EEOC, and the EEOC says, yeah, this discriminates against African Americans, or discriminating in other countries. So is a reactionary application of the law the solution? Because the individual or the agency that's trying to generate the AI product may not be able to see everything. And it looks to me like it's a bottomless pit. I don't know the answer to the question, and that's why I'm putting it to you. Is it a reactionary type of check that we need, or is it a proactive check, which is what Mario was asking about? I don't know if Brenda wants to talk about this.
So I think that's, I think that's exactly the right perspective in terms of why I was sort of saying earlier there has to be internal oversight, there has to be external reviews of that internal oversight, and then of course there's regulatory standard setting and enforcement of whatever the value that we've placed on that is, and the boundaries that we've set for that. I think a little bit, though, that still reflects the idea that somehow this is happening or operating differently than what we've done in the past. And I just want to push back on that a little bit again to say that we didn't necessarily know what your shifts involved before you started using AI. And you used some other new form of business operations or technology, and you measured your business outcome, you measured your compliance performance. If to use the employment example and the EEOC, they don't tell you what you have to do to get to the outcome that's sufficient. They're just going to look at your employee register, and they want to make sure that your diversity or that your employee pool doesn't reflect an unfair bias against whatever demographic category. If you got there by rolling dice, or if you got there by an AI system, or if you got there by a really well-meaning HR person who did a great job, you got there, and that's what they're going to be looking at. So where I see the distinction is where we know what the standards are, like an existing employment law or an existing anti-discrimination law, and we can apply the long history of precedent and content, as Alvaro has mentioned several times, that this has to operate within that. I actually think is easier if we would all sort of take that perspective and acknowledge that's what we need to do. The harder part is around where we might be doing new things that we haven't done in the past, and we're trying to now establish those values to reflect in what the regulatory stance would be. So for example, in some sort of targeted advertising, which is not an illegal activity to target the place where your business is going to succeed, to sell warmer coats in colder climates, to sell more expensive cars by advertising in more expensive outlets and platforms. But when we get to the point where the level of data involved is such that we can literally target individual people, and we have to start answering the question, at what point is it targeting versus exploiting or manipulating individual small groups or individual people, that's where we then have to come back and say, okay, we need to maybe draw some sort of value-based regulatory line, because it's not whether the technology is working right, and it's not whether it's reaching an illegal outcome, but it is reaching new levels of performance that we haven't been able to do in the past, that now these systems are allowing us to do, and that's presenting a whole new question that we haven't even had to answer before. So I see that as some of the places that again, to go back to Dan's opening remarks, was this is all still malleable. There's all still a lot of new things happening, and so we can't lock everything down, even into the very valid systems that we have, because there are so many new challenges in some ways.
Thank you. Look, I think we're sort of tight on time. This has generated a lot of interesting discussion. So I have one more question from Peter Drake, who is online. What are the downsides of AI innovations like ChatGPT? How should these be regulated? I don't know who wants to answer that one.
So I sort of anticipated that we would get some question about ChatGPT. I just to put a little bit of foundational information out there for the conversation. Just as machine learning is a whole new version of algorithms, every computer program is an algorithm. It's a set of steps to achieve an outcome. Machine learning is an adaptive set of steps that can be adapted without direct human involvement. That's why it's new and special and different, and that's why it is a significant part of AI and raises a lot of concerns that we've been talking about here today. ChatGPT is sort of a next level of machine learning, which is called generative AI. And it's an entirely, I don't say entirely different, it's a significantly different way of programming AI systems, even past what we would have been calling machine learning. And right now it's content generation. It's videos, text, art, graphics, things that it is generating new content based on the content that it's been fed of, existing text and video and images. And that is substantively different than what traditional machine learning does. Those systems can still be audited. We do those kinds of audits, but it's a different set of measures because it's generating a different type of output. So instead of doing pattern analysis and generating recommendations or scores or rankings or labels, it's actually generating new content. And so you have to consider that differently. It can still reflect bias. A quick example is that ChatGPT, if you ask it to tell you a joke, it's most likely going to tell you a joke that's sort of based on technology. It's a tech type joke. If you ask it to tell you a joke that's not based on technology, chances are the joke won't be as good. One of my partners and I, one of the ones who's a computer science, and we've been playing around with ChatGPT, and we've been trying to stump it, trying to find what can we do that makes an obvious bad outcome, because a lot of its outcomes are amazingly good. But what can we do that's an obvious bad outcome? And that's one of them, is getting it to stump a joke. Another quick example is if you have a conversation with it about phrenology, it will tell you that that is not valid science and that that's not to be relied on. It sort of will discuss what it is, its history, things like that. It's very useful, but it will continue to tell you that that's not real, that that's not good science. You shouldn't be, basing any sort of decisions on it. But if you turn around and tell it, build me an argument for phrenology, it will do that. It will build that for you because for whatever purpose it thinks that you need that. Maybe it's, devil's advocating something or whatever. So it has good contextual awareness in terms of some boundaries on things, but you can work around them and you can get it to reflect other things that you want it to because it's always just going to be generating out of the information that it has. And I know Dan has the great example of his bio for ChatGPT. So
yeah, this has really been sweeping over academia, and a lot of professors are very nervous because if we give a take-home exam or a paper, students can just generate the answers and you can't check them. So if someone plagiarizes, you can check it to see if it matches anything. But this is new; it's generative, and so you can't check it against anything. So it's very hard to tell. And then people have been feeding it exam questions, and it's doing so. It gets like a C or B minuses, and it's still not getting. It's not an A student, but it's getting there. In a couple of years. I asked it to actually write a bio for me, and it gave me a clerkship with Judge Guido Calabresi that I never had, and then it also gave me a PhD from Berkeley, which is nice. So it's nice. I got all sorts of extra credentials. I don't know why it did that because there are certainly authoritative bios out there on me just from my law school website, but I think it's a matter of time before those little issues get worked out. I don't think they're going to be that hard, and we're going to see this develop over time. It's going to be really hard then to tell the difference or be able, at least as an academic, we're all very concerned, how do we ever detect if a student has used this to generate their papers or take-home exam answers? So no one knows the answer, but everyone is freaking out right now in academia.
So I think we'll be debating this topic for a while. In fact, there's an interesting site called character.ai where you can talk to various historical characters. I don't know whether you've seen that, but I found that there were several Franklin Roosevelts when I went up there. I was a little concerned about some of the responses I was getting. So clearly some food for thought, and the debate won't stop here. But unfortunately, we have to stop this session here now. Dan, Alvaro, and Brenda, thank you very, very much for the interesting session. So We'll take another short break, and I think this one will be a little bit shorter than the previous one since we're a little bit over time. So if everyone can be back here at 11:10, and we will have the next session, which I think again is very topical because it'll cover the current privacy issues, and Dan will again take the floor. So thank you.
As a global institution, it is extremely challenging to navigate our complex and constantly evolving environment. New privacy laws are being adopted all around the globe. They introduce complex and fragmented standards. These standards sometimes diverge or even conflict with each other. So how do we keep track of all these developments, and how do we ensure compliance? New technologies are also quickly emerging. They, of course, offer huge opportunities, but they also amplify risks for people, for society. Think about the risk of bias, discrimination. So how do we maximize the benefits of new technologies while minimizing their risks? So at Mastercard, our recipe for success has been to instill a culture of privacy by design across the organization. In practice, it requires multiple teams to come together, and we co-design our solutions or innovations, and we co-implement remediation actions when gaps are being identified. So the goal is to embed strong privacy and security controls into everything that we do, and keeping the individual top of mind. Now, to get this right, it requires us to stay laser focused on 3 areas: on people, on technology, and on partnerships. So let me start with people. Talent is our biggest asset. So do we have the right talent in-house with the right skill sets? Do we need to upskill our existing employees? Do we have sufficient diversity on our teams? Without the right talent, privacy by design may not be effective. And today, as we all know, we face fierce competition to get the best talent in these areas. So having a strong people strategy is absolutely key. And then second is technology, and technology is definitely part of the solution. Do we have the right tools in place to simplify how we support our business and to minimize our risks? Can we automate some of the work, right, to accelerate and scale our compliance efforts? It is also worth exploring some privacy-enhancing technologies. These technologies enable data to be shared, to be analyzed, without revealing the underlying data, so that we fully protect people's privacy. Such technologies have huge potential to enable businesses and societies. And then last but not least, partnerships. I am a strong believer in the power of partnerships. In today's highly interconnected world, privacy risks do not exist in a vacuum. They often involve multiple parties across the whole ecosystem. Think about it. If you implement strong protections to protect people's data, but your suppliers don't, people's privacy is at risk. It is therefore mission critical to have strong governance in place to protect people's data end to end across the whole value chain. So these are the 3 elements of our winning formula to make privacy by design a reality and a success.
Hello, my name is Trevor Hughes and I'm the President and CEO of the IAPP, the International Association of Privacy Professionals. And I'm delighted to be chatting with you today about something that is a hot topic all around the world, and that is privacy. I'm also really happy to be joining you and the World Bank in recognizing Data Privacy Day, a day globally set to recognize privacy issues, privacy concerns, and promote understanding and better practices around the world. What a complex world we are in today. As we look across the legislative environment globally, we see that privacy, that data protection has indeed become a major issue. Over 100 countries now have national privacy legislation in place. And every year we see more and more countries adding national privacy legislation. Certainly, much of the world is guided by the foundational work of the European Union in the GDPR, the General Data Protection Regulation, but there's more than that too. In fact, Gartner, the major research firm, estimated that in January of 2020, just 10% of the world's population was subject to national privacy legislation. By the end of 2024, just 5 short years from the start of their research, Gartner estimates that 75% of the world's population will have national privacy legislation. In other words, in 5 short years, 65% of the world's population will have brand new national privacy legislation. That means that we have a complex, a varied, a multifaceted environment for organizations to navigate as they are dealing with issues of privacy around the world. And make no mistake, these new laws have risks associated with them. Individuals, data subjects, citizens, customers, they all expect good practices when it comes to the handling of their data. And these laws give life to those expectations. Many of these laws include the ability for fines to be applied. Many include the possibility for complaints to be brought to courts by individuals or other organizations. All of this adds to a very challenging environment for organizations today. So you may ask yourself the question, what do we do? How do we respond to hundreds of new privacy laws emerging around the world? How do we answer to boards of directors, to executives, to customers, to citizens when we are dealing with issues of privacy and complexity and risk? And there are no really simple or easy answers, but I think there are some ways that you can always start. Having smart people in the right places making good decisions is always a smart thing for an organization to do. Let's go through that list really quickly. Smart people, make sure that those people in your organization that are handling data, making decisions about data, setting policy for the use of data, understand the obligations that apply to your organization, and they're well trained on data protection and privacy expectations. Make sure that they're in the right places. It's not just a legal department issue. It's not just a compliance issue. Data practices exist all across organizations today. Customer service agents, tellers at banks, product development professionals, marketing professionals, human resource professionals, they are all touching data, and the data that they touch may come with major compliance obligations for your organization. So make sure that you are applying appropriate data practices in all the right places. And then make sure that you're making good decisions. And let's be really clear. The law is the starting line, not the finish line. What the law says sets a baseline expectation for data practices in the marketplace. But your customers, citizens in your country, those people for whom you manage data, they are going to have expectations that often exceed those legal requirements. You want to be in a place where you are generating and building trust in the digital economy. And maybe that's what Data Privacy Day is all about, that we are the guardians of trust of the digital economy. That's an incredibly big job. And we are very happy at the IAPP to be a major part of helping to train and prepare professionals around the world to deal with these incredibly complex issues. I wish you the very best on this 2023 Data Privacy Day, and I wish you the best of luck as you navigate these challenging issues in today's digital economy.
All right, we went a little bit over time on that break. I think in some ways, I know that when you're here for half a day, you do need some of that time. Look, this second session, again, is extremely interesting. I think there are just so many cross-cutting issues associated with privacy, and some of the questions I think that still linger are questions such as how can we best transfer personal data across borders while ensuring a reasonable level of protection? What assurances and transparency should individuals seek when asked for their biometric data? What are the hallmarks of an effective, transformative, and privacy-conscious digital identity program? All, I think, novel issues. So, again, I will be asking Dan to introduce a wonderful panel, and thank you, Dan, again, for leading this session on current privacy issues.
So I'd like to do our introductions. First, Justin is the founder and CEO. Justin Antoni Play is the founder and CEO of WireWheel. He was acting Undersecretary for Economic Affairs at the U.S. Department of Commerce during the Obama administration, and he led the negotiating team in reaching the EU-U.S. Privacy Shield framework, which later was struck down, but now it's coming back. It's going to be back again. And Heather West is Senior Director of Cybersecurity at Venable. Previously, she was Director of the Privacy Policy Team at one of the world's largest social technology companies. Welcome to both of you. And I'd like to kick this off with a very general question, which is, what are the privacy issues that you're thinking about the most these days? What's the hot issue in your focus right now?
I'll kick us off. The funny thing is, when I was thinking about what I wanted to talk about today, I started brainstorming. And it became very clear very quickly that the actual answer was everything. We're talking about everything here. Dan and Justin and I just now were talking about how years ago, this was like a limited number of things. There were a small number of topics that we looked at and we said, that's privacy. We're thinking about this really hard topic. What are we doing? But now we're talking about everything. And so it's that intersection between different topics that I think is really, that captures my brain and my bandwidth on a day-to-day basis. What does privacy mean in the context of X or Y or Z? And then bringing it into other kind of policy questions. Alvaro was talking about how antitrust and competition come together with privacy at the FTC and other. We're seeing more issues in the context of privacy, which is to say that I'm thinking about how some of this translates and how we use kind of existing knowledge and know-how to inform data and data governance. I'm thinking a lot about what it means to have a robust privacy program and to have clear accountability and processes for your organization, for your company, for whatever problems that you're thinking about, and how you can do the right thing, think about things in the right way, build a robust governance structure that means that, well, as Brenda said, you won't get it right all the time. You have a good chance of getting it right most of the time, and thinking about how to build that in a responsible, robust way.
All right. Heather, that was terrific, and I agree with you. Dan, I think it's a great question. And by the way, thank you to the World Bank for hosting us all here this week. And you have a fantastic team. And, the World Bank is setting an example by running a very forward-leaning privacy program, even though there's no legal requirement to do so, which is kind of a neat principle to set here and around the world. I'll cover two things just by way of observation. And I'm gonna start with an example. I want you to imagine that when you were filling out your taxes every year, okay, that there was no tax form that you had to fill out. You just got to go in and declare what income you have, but income wasn't defined. And then you would define how much you had to pay in taxes. And then you would create a form and you would fill it out and you would send it into the federal government saying, this is how much taxes I owe, and here's your payment. Okay? Just imagine that for a moment. Now I want to highlight to you the way that we see privacy program management run almost everywhere, and it's one of the craziest things. I'm just going to be provocative for a moment, okay? It's one of the craziest things I've ever seen, because the general laws out there define that you should go out and assess your privacy programs, okay? But if you go to any company anywhere in the world and you start by asking the question, what is the thing you're assessing? Just what exactly are you assessing? Everybody has a different answer, literally. And I'm saying to you, within the same company, multiple divisions have a different definition of what they're assessing. Within a single consulting firm, global consulting firm, every partner defines it differently, and it's because it's defined globally by virtue of GDPR on the concept of a business process, which nobody has a standard definition of, okay? So all around the world, there is a principle of assessing a thing that you self-define using a program that you create based on principles that are vague. That is a really, really weird set of circumstances, to be honest, okay? So what I think is a major movement that you're gonna see this year, I think driven by what I'm seeing out of the United States here, Colorado and California, is some standardization of what is the thing you're going to assess, and more importantly, what are you actually going to file with the government, okay? And here I'm gonna focus on an unsung hero from the 1900s, Mabel Walker Wildebrand. Does anybody know who Mabel Walker Wildebrand is? Okay, so in the 1910s and the 1920s, it was virtually impossible to prosecute anybody who was in gang violence. Now why? Because nobody would testify against them, okay? You have a gang and you're running, alcohol, everybody's scared of you. And crazily, there was a principle that folks accused of crimes had where they weren't filing tax returns. Now, why weren't they filing tax returns? Because they would claim filing a tax return violates your Fifth Amendment right against self-incrimination. And crazily, by the way, I love this. This is bold. But they also said, hey, if I were to file a tax return and pay something to the federal government, you would never want to profit from ill-gotten gains, so I don't need to file a tax return. Now, Mabel Walker Wildebrand thought differently. And she said, you know what, we're gonna bring a case on this, we're gonna prosecute you because you have to file a tax return. And she won a case, US versus Sullivan, in the Supreme Court in 1927. And that has been one of the major drivers for enforcement because you have a single form that you have to file everywhere, right? Everybody knows what your tax return is supposed to say. You file it, you certify to it, and now you can actually enforce it, okay? And so what I think is going to be a major opportunity, I don't know if it's going to be taken advantage of this year, but to me it's one of the greatest opportunities California and Colorado have. Define the form that companies have to file saying exactly what they did with your data, make them sign it under oath, just like you do a tax return. And if the two states and the others that have any kind of filing requirement take advantage of that opportunity and they make the form the same, for the first time, you'd actually have something enforceable. Because to be honest, if the requirement is you assess something that's undefined using a methodology you define and you put that file in the form, there's no enforcer on earth that has any ability to enforce that. So I would say there's an opportunity in California because both California and Colorado have a requirement to actually do something and define it and have it filed with the government, that you could actually drive a lot of change. And by the way, I know Dan well. Dan and I and Heather have been on a lot of different panels, so he's about to jump in and criticize me. So I'm gonna, just like any lawyer, I'm gonna blunt the force of this. He's about to say, if I'm predicting Dan correctly, listen, what are you gonna do with self-declaratory statements, okay? You just declare that you did it right. There's no teeth to that. And I think he's right within a band, even though he hasn't actually made the point yet. He will be right within a band, but to be honest, if you have to file something under oath that says you did something and everybody has to file the same form, you can actually start holding people accountable. And I think that would be a huge, huge change. And you're not seeing a ton of this in Europe because everybody is creating their own forms and there's no standard form and not even a single country can agree on what the heck you have to do. There's no standardization anywhere. And by the way, I will put it to companies too. It is very difficult to implement a privacy program, even if you're trying to do the right thing, if you have no idea what the output is supposed to be. Like nobody has declared this is the thing you have to create. So I'd say that's the first major movement, and I promise I won't go any further other than to say the focus on ad tech and MarTech here in the United States is going to change a lot. It's not going to change in 1 year, but it's going to change a lot. And the way I would say it is, as of January 1st, 2023, ad tech and MarTech is a regulated industry now in the US, especially under California law. I would just think of it that way, and I think that's going to drive a lot of change this year.
So, well, I guess after hearing Justin's remarks, there's that old saying where, like, the only certainties in life are death and taxes. Well, now I can say it's death, taxes, and privacy. I mean, I agree on the accountability point that, having, telling a company just do a data protection impact assessment and just leaving it at that really doesn't create enough accountability. Having it filed with the government does create more accountability because now someone's going to actually look at it and really be able to scrutinize it. I think one of the challenges, though, is, what does it mean? What are the standards that are going to be applied to these? The quality of them. So I think one step is to have accountability, but then we also need to think substantively, what does a good privacy program look like? And what are the metrics that we're going to look to evaluate that? Is it that, hey, as long as you, fill out forms and you have all this paper, it's good? Or do you really look at, how good is it? Because how do you do a privacy impact assessment? I always say, you need a concept of privacy to do that, because a lot of times, a privacy impact assessment is just the data's encrypted and there's access controls and therefore we protect privacy. There's so many pieces to privacy, so many components. It's such a complex concept and a lot of debate about what that is. So I guess thought would be, how do you build a privacy program? And then ultimately, how do we evaluate whether it's any good? What do we look at for that?
I love these questions because at the end of the day, I work at a law firm, but I'm not a lawyer. And I care about compliance, but I care about building the programs that get the things right more. The compliance can follow. I think that when you're thinking about building that program and thinking about backing up and saying, okay, we are well in the world of privacy, we are well past the point where someone stands in a room and says, that's good and that's bad, and that's good and that's bad. Which I think we were doing when we were paying attention to particular practices. But when you step back and you say, what is the process? Let's document what the process needs to be. And instead of thinking about good and bad practices, let's talk about risk management, and let's talk about the context of what that we're operating in, the context of services we provide, the context of the people we're interfacing with, and putting that on paper. And maybe it's not all in the same form yet. Wouldn't that be the day? If we said this is the shape of our privacy program. But you can start looking at things like the NIST Privacy Framework or other places that say, aha, how do you do this? And how do you do this? And then you can point back to it and say, we did our best. And that in and of itself, I think, goes a long ways for a privacy program. Obviously, there are some players whose privacy program is going to be the subject of more scrutiny than others. And those folks are really good to look at and say, aha, how are you doing it? And then you can decide which piece of it you like and which piece of it you don't. But I think that sitting back and thinking proactively about that is such a big piece of this puzzle. As companies have sat back and said, we need a privacy program, what does that mean? They have been coming up with it from whole cloth. There's been an evolution of what that means. I think the other piece of this that I will say is that when you're thinking about that privacy program, that accountability, a huge piece of it is building agility and robustness into that. You are not going to come up with these processes once and decide, aha, I have it figured out. These are questions that are going to continue evolving over time, and they should. Suddenly we have ChatGPT, we have all of this generative AI.
Do we have to think about that differently? Probably not. But do we need to tweak the way that we're thinking about this and tweak the way that our program evaluates new processes, new procedures, new processing? Yeah, probably. But I am firmly of the belief that there's nothing new under the sun, but obviously a theme so far is that this is all malleable still. We are figuring this out and we are working on it, and so building that into a program is one of the things that I think a lot about. How do you build it so that it stands the test of time?
No, Heather, I mean, I think that's exactly the right framework. I mean, you and I are going to agree on a lot of things today. I would start with almost everybody with the following if I were trying to be just how we talk about it with our customers. If you think about the focus that's just happening on the way you engage with people who visit any of your websites or channels as one of the first places you should look, it's been really amazing to see that once you start focusing on your ad tech and the MarTech and the way you're engaging with your customers or visitors, even if you apply basic privacy analysis to those things, they start to raise questions. And this is an example. California has started with a lot of their regulation. I'm going to come back to California a fair amount because I think that state is going to drive a lot, not only here, but around the world in the next year to 2 years. I do think Colorado, Virginia are going to have voices, but California really seems to be ahead of the game. So, the way that websites and other technologies were built, they really were about when you land on that site, data is going automatically from that site to third parties immediately, okay? Now, you don't have to be a privacy genius to be worried about that, like if you just think about it for a second, because there's no governance on that, really, right? It doesn't actually pass. Let me just give you, I'll use hypothetical shoe company. I'm friends with a lot of the folks that are at the shoe companies, and to be honest, they hate it when I use an example using a particular brand. So let's just call it shoe company. You land on the shoe company site because you're interested in a new model. Well, starting, let's call it 2 years ago, I would bet you money that the minute you landed on that site, data about you, based on your what are called probabilistic IDs, your IP address, your user information, your user object information, was immediately shared with most of the social media sites, and it didn't actually ever pass into the shoe company. You know what I mean? So it's an odd flow of data. They're visiting your site, you're responsible for that site, you care about your customers. If you talk to any marketing person and you ask them at that shoe company, are you selling data? They'd be insulted. Of course not. I would never sell my customer data. I would never share it without governance, when literally 100% of the people visiting that site, their data was going to a whole slew of third parties, okay? Then the next question we get on a really regular basis is, well, when we're collecting choice or opt-outs, of consumer choice, why would we collect those opt-outs without making somebody identify themselves, right? Which is a reasonable question. What am I going to do with it? If somebody comes and opts out and they've opted out based on their anonymous IDs, their IP address, what are we going to do with it? And if you just merely ask the same question back, when somebody visits your website and they haven't identified themselves, are you still advertising to them? Well, yes, then you need to opt them out of that. It's the same analysis in reverse. So I'd say the flow of data in ad tech and MarTech involves a lot of flows that are, like, if you think about it, ungoverned the way we think about privacy. And I'd say the California focus on that one issue is probably going to change a lot of the ways we just govern that problem. And Dan, I think that the only other comment I would make on this is the ad tech, MarTech industry is like amazing once you just dig into it. It's just amazing the way they to be fair, a lot of the things we love about the way you interact with different things are driven by the fact that they personalize their experience to you. And you have to give credit to that. In other words, when I go shop for a book and I go to a retail site, I do kind of like the fact that when I shop for the book, it recommends other books I like, and I often buy the books that they recommend, and then I like the books, right? But that's personalization. And what you're likely to see in the next couple of years from the ad tech, martech side is retail media networks that are based on almost every retailer's site, okay? So you're starting to see grocery stores, when you go shop at a grocery store, in their store, they're actually serving ads to you from the things that they're selling at the store. That's a retail media network. You've gone to the grocery store to buy your groceries, but you're actually getting ads from the grocery store chain for other products that want you to buy their store. That's advertising to you based on your behavior on the site. That's an amazing kind of crazy concept. So I guess I'd say to you, Dan, there's a lot in terms of the privacy program that I would really defer to Heather in terms of some of the principles she set out. But I would focus right now on your marketing and your marketing stack and ask about not sale of data, but exactly how are you sharing data in order to make your marketing program better? That's the best question you can ask.
And to build on that a little bit, sorry, I will just hop in again. I think that there are two pieces of that are really, really interesting. Yes, you have to dig into the technology. How does this really work? But that goes to some of, you have to map your data flows. You have to think about how this is working. But a more fundamental piece of what you were saying that I think is important is that a lot of the issues we're grappling with are a mismatch between what people expect from their interactions online and how the technology was designed in the first place. My background is actually computer science and cognitive science. As I said, I'm not a lawyer. And so I come at this and I'm like, well, of course they're doing those things. That's how the protocols were designed. And then we have to back up and say, oh, okay, maybe that's not exactly what it was designed for. I don't think they were thinking about marketing tech and these vast networks of information sharing that go to tell me which shoes I am going to love and are often right. And when they're right, I love it. When they're wrong, it's weird. And so there's a question there. If you're designing your program, you need to be talking to the techies. Who built this? Who can tell you where the information really is? And you need to be designing these interactions in a way that I, as the shoe customer, as opposed to the privacy expert, I get to go do what I want to do on your website at the same time that you're respecting my privacy without making me click through 5 million buttons to get to those dang shoes.
I think you both are really interesting points, and if we want to map, like, okay, let's say we want the consumer not to get unexpected things, which I think is good. One of the challenges is there's a lot that's unexpected, and it's harder and harder with modern technology for consumers to really kind of understand what's going on the back end, and to really know what might happen. And I think people like ads until they don't like ads. Sometimes it's great, sometimes it's not so great. Sometimes it's creepy, sometimes it's not. And it's really hard to get to that. I don't think ads are inherently bad, but how do we separate the troublesome parts from the good parts? The law, I think, often tries to not want to go there. It doesn't want to look at harm and risk and use. It tends to want to just make a kind of more of an abstract type of way, or let's just define sensitive data. And I actually wrote a piece saying I'm not sure sensitive data works in a big data age. Everything can give rise to inference of sensitive data. So everything is sensitive data. But that's a whole other conversation. But when it comes to harms and risks, how do we determine when an ad is harmful and when an ad is helpful? Obviously, the ads are going to make mistakes. It's not always going to be right. We should say, well, it's always bad if they make a mistake. If it's just, you dump something in a privacy notice and that the consumers never read, that really doesn't solve it either, because people don't read them, and So we can't do that. So we need to figure out, well, what are, okay uses and what are uses we don't want. I think a lot of the solutions I see are kind of, well, let's just stop the ads or do something that makes it impossible to deliver the ads or really hard to do it, or do nothing or do something meaningless like, let's just throw up a cookie banner where people click accept just to make the thing go away. Not because they want cookies or do anything, because you don't want to go through the 1,000 different, do you want every flavor of, more flavors of cookies than Girl Scouts around the world could sell. I just want to see the website. I don't want to deal with all that. So I'll click accept. I don't really want the cookies. I just don't want to be bothered. So how do we deal with that? And ultimately, I think someone has to make a decision what is good and what's not good. And then, so if we go down that road, I mean, who decides and how should the law regulate this? Should someone be saying yes and no to things? Should we leave it generally to the companies? Because a lot of the law typically says, well, we don't want to do this. So we'll just they'll just say it in the policy, and then, if people don't like it, they can opt out. But we know that doesn't really work. So what do you do?
You ask whether someone should say yes and no. Absolutely. Someone should be saying yes and no, except instead of one someone, it's a lot of someones. And within this ecosystem, you're talking about the regulators, you're talking about the companies, you're talking about the NGOs, you're talking about the users, you're talking about this huge network of people. And we are all people making that final call. We don't have AI that is making the call for us yet. And I kind of hope that we wait a while before we think too hard about asking something like ChatGPT to make that call. Because I think, as you said, Dan, it's a solid C student. The actual answer, and this is a little bit of a punt, is that the important part of this is really sitting down and understanding the people that are impacted and why they're impacted and how. Because at the end of the day, what I look at and I say, this is good or bad for me, is not the whole picture. And we seem to, I think, as the privacy community, have moved well beyond the idea that there's someone in a room who makes that call on their own. There is a process, there is a discussion, there is someone, and many someones who are involved in that conversation about whether or not it's good or it's bad. But at the end of the day, a lot of this, we are making decisions about systems that make a guess about me and my shoes or my books or whether I'm going to be a good employee or whether I get health care or any of these decisions of greater or lesser impact. And we are thinking about what that looks like. And my cop-out answer is have the conversations, a lot of conversations, so that when you're making a guess about whether these systems that are making a guess based on data, it's a good guess. And we're not going to get it right all the time. The only way to get this perfectly right is to ban it all. And then we'll get it perfect because we just won't do it. And if we've decided that that's perfect outcome, great, we got our A. But the actual, for me, the goal is to have progressively better conversations and make progressively better guesses about who benefits and who is harmed by these technologies. And if we do that and we continue to move forward, then I'm going to be happy. Are we going to use more tools and better information about the impacts? I hope so. And are we going to pay more attention to the parts of society that maybe haven't been considered in the same way? I hope so.
Heather, you've clearly run huge programs and part of it, so your insights are critical, I think, on these issues. And if I were to try to build on what Heather just covered, I'll start with California. What is California doing as a starting point, and where are you going to see enforcement for the next 6 months? There's an enforcement decision that came out in California in August of last year against the manufacturer of makeup, Sephora. I don't know if you all have heard of this, but it's an important one. And what they did there is, what the Attorney General in California did there is, Sephora, if you look at the complaint, was sharing data from their website out to normal marketing platforms that are extremely widely used. There was a pixel that went to a social media platform, and then they were sending data to one of the major search engines to help them understand analytically what was going on the website, okay? I would bet you 90% of consumer brands are using something similar. California said, number one, because Sephora took the position, that's not a sale of data. We're not selling data. The sharing of data for the purposes of improving our ads, measuring the performance of our ads, frequency capping, all normal techniques, they said that's not a sale of data. And California said, no, it is. It is a sale of data. And they fined them a little over $1 million for this site. And they said you have to do three things. First of all, you have to wrap all that automated marketing technology and make sure it doesn't fire if somebody decides they don't want it. That's a simple principle. By the way, there's a focus around the world of getting rid of pop-ups from a user experience perspective, as Dan was saying. People hate them. They interrupt your user experience. It often throws up like 50 choices into the middle of it, and you can't do anything until you go on. And let me just say, as a human being that walks the earth, okay, how many people do you know that know what a cross-contextual behavioral ad is? I mean, that's not something people are born with. I wasn't born with the knowledge of what a cross-contextual behavioral ad is. So you get a choice. Do you want a cross-contextual behavioral ad? I don't know anybody that knows what the heck that means. And how many people do you know are going to look at that and then go look up what a cross-contextual behavioral ad is? So these choices, as Dan are putting up, California basically said, don't interrupt their consumer experience. Get rid of the pop-ups. Make it easy for them to come and make the choice. And most importantly, you have to implement this new technology, a global privacy control, so that you set the choice once in your browser of like what you want to happen, and it drops that without you having to do it on every site. That's a starting point to what Dan is getting at. And I think between now and the middle of the year, you're going to see California very reasonably and aggressively enforcing this and say you have to start changing the way you get permissions. What I'm worried about, Heather and Dan, and I don't know either your perspectives on this, by mid-year, with the 5 states starting to come online and California's second version, there are something between 9 and 32 new choices that have to be presented to a consumer. That is a lot. That's a lot. And even if you tried, Dan, to explain every choice and had a little animated cartoon that said, like, here's a contextual ad and here's a cross-contextual behavioral ad, I don't think anybody's going to watch them. So we see a lot of companies trying to do the right thing, trying to figure out how do you put this up, how do you make a better user experience, how do you share the information. But when you start to getting to that many granular choices that are mandatory, from the human being side of it, I'm worried that people are going to get frustrated, overwhelmed, and they're going to just start doing what Dan suggested, which is just click through it and move through it. So I don't know that I have a great answer. I do know a lot of people are trying from a user experience perspective to make this better.
And it's incredibly hard, but like making sure that this is usable and respects people, not checklists, is really critical. 32 choices is a lot. And then actually when you're talking about the company implementing it, and I love, by the way, that we're doing like the government piece and the regulatory piece and then the company piece, and so it makes this a very nice pairing. Like from the company side, fragmenting their service into 32 to like different choices, and then all of the permutations of those choices, and what does their system really do? Like that's actually hard. So it's hard for everyone. And my suspicion is someone's going to come up with a good way to do this, whether that's kind of the global privacy control or something else. Maybe it's you. But putting that burden on the user, on the people who are using your website, is just bad for everybody.
No, I agree with you. As I said, I'm empathetic to all of the parties in this thing. The government, I think, especially in the States, they're thinking about the right thing. I was looking at they have this out-of-home advertising. So you think of it as like a billboard company, okay? Well, billboard companies are often now linked to be able to retarget you based on whether your location data shows that you saw the billboard. How many people knew that? Like, not many. And some people don't feel that comfortable knowing that, hey, I don't mind, billboards are public and I know I'm gonna see them. But I don't think many people realize that when you see the ad on a platform later that happens to be the same ad that you saw on the billboard, the reason you got it was that you drove by the billboard and somebody knows that you saw that billboard. And a lot of people wouldn't feel comfortable with that, right? So, but how in the world do you put that choice to a person? I don't have an answer to that. We are testing a lot from a UX perspective, but the complicating effect is what you both have really identified. People like some personalization, and there's some personalization they don't like, and it gets back to a quote that comes up in law school. You kind of know it when you see it, but it's hard to define exactly when it's crossed the line from being a comfortable personalization to an uncomfortable personalization. That's my perspective right now.
Yeah, it's really tricky because even with the global, sometimes I want some cookies from sites. I don't want to have to log into Amazon every time. Sometimes I want the data to be shared. Like I would like it if I go to Uber and it would just say, okay, I know from this other data on your phone that you're going to go to the World Bank today. So I can it would just say, first thing would just be World Bank. But it doesn't do that. I have to type it in and whatever. But it'd be nice if you just knew it, and it could if it got more data. So, but the problem is there are other times where I don't want it to know it. But how do you know what that's going to be? And if we then have to make the consumer has to make the choice in each individual situation, well, that doesn't scale. So that's sort of the big problem. If I know it when I see it, is so well, how do you know it when you see it? Because different people have different views, and then different sites operate differently. So it's not a one size fits all, which is the real challenge. Is how do we create a rule set that's really going to best capture all this? I think this goes not just for businesses, but just generally for privacy for all organizations. Has this large meta issue of how do we regulate this in a way that is not so general, and I think this kind of general regulation of just kind of put something in a policy, do the right thing, create some documents, and call it a day doesn't really work. But then if we're going to drill down to something that does, it's hard because there's a lot of very difficult choices and also different views of the harm. Some people think ads are much more harmful than other people. Some people think ads are annoying, but not necessarily that harmful. And then there's different kinds of ads. Sometimes some advertising is okay. Some advertising is more manipulative. Is something Ryan wrote about. When something gets too far, and how far should an ad go? How much of a person's behavior should an ad analyze? And when is that crossing a line? And that's tricky because what is the line? So that's where we are.
Dan, another interesting discussion. Thank you also, Heather and Justin. There are some questions, so I'd like to pose a couple, but I apologize in advance as we're running out of time that we won't be able to address all of them here. However, I'm going to ask the team to take note of some of these, and maybe we can get back to you. But there, let me just start off with one question. If you had a magic wand and you would like to see one change happening in organizations to manage privacy risk for their stakeholders, what would that wish be? And this is for all three of you.
I don't know why we're starting in the middle. If I had a magic wand, I would ask organizations to bring privacy in at the beginning of their thinking. We can all scramble at the end and say, oh no, maybe we can put this control in. And you were talking about kind of wrapping some of the marketing and ad tech so it wouldn't fire. But if you had been thinking about it, and if you'd known that requirement earlier, or you thought about that requirement earlier, you could have designed it all differently. And sitting back and saying, wait a second, with a diverse team full of thoughtful people whose job it is to spend some time, like you're not racing to the finish. Spend some time thinking about how to design this right. It'll make it easier for everybody in the long term, and hopefully it will serve people instead of just trying to exploit the really cool thing that the network does in order to get a little bit more data out of someone.
So I would say that, if I had a magic wand, I'd make them all organizations should buy my books and read my scholarship. There you go. But in all seriousness, an answer that's actually not too far away from that, which is, and it goes to your answer too, that when they're thinking about privacy, before they just kind of launch in and start doing stuff, is even, and I definitely think the beginning of the process, is to actually think about what privacy is. What are the problems you're trying to solve for? What are the issues, so that there's a complete understanding of privacy? Because I just see time and again folks think, oh, we'll just address a couple things, and then everything else is ignored. So you really need to think broadly, and even there's privacy, but whether you and Ryan, I have this ongoing debate about what privacy is, and I think you have a much more narrow definition than mine. I kind of think privacy is almost everything, but with some limits. Ryan wants to police those limits a little bit more. But generally, I think for organizations, all the problems, like we shouldn't leave anything off the table. Any kind of harm that could be created by what you're doing, you should think about and figure out how to address. So I think it's really important to spend the time thinking about that, which has to be done early on. So if that magic wand, and that does involve, I guess, getting my books and my scholarship, but also that of a lot of other people too.
Are we allowed to just endorse? Like, why are we all going to throw that out? I didn't even realize that was an option. I should have had wire wheel everywhere, Dan. If I were to wave a magic wand for businesses, it's a parallel to what Heather and Dan covered. I would say start with understanding what are the 4 or 5 problems you want to solve that year. Like literally, what do you want it to look like? And the reason I say that is right now, almost everybody's website in the United States has to change in the next 6 months to a year. They don't want cookie pop-ups. You have to have a different way to receive the data. Interacting with your consumers and people visiting your site and making sure you actually have governed the way stuff works, to me, is a really high priority because it's just a regulated thing now. And second, I would say we go into a lot of businesses or organizations, and there's been this theory put out there that the only way to solve privacy is to literally boil the ocean, discover all of your data, then go and build a model on top of the data, and then you can be compliant. And the truth is, the explosion of data inside of organizations is arithmetic. It's not something you can do that way with a reasonably sized team. And so trying to go boil the ocean and discover all of your data without understanding what is the thing you want to solve, we've seen that drive people bananas. Because I'll just give you an example. If you went to discover data in a moderately sized web application that your development team builds, chances are there's more than 1,000 data elements in that one web application that is arguably personal data, because it's the logs, the telemetry, the account. So when you do that, you now have 1,000 data elements, and you have to do something with it. and that's not even your highest priority. So having a strategy that's actually tied to your risks and then understanding your resources and going to tackle those high priorities, you can accomplish a ton. But the boil the ocean approach, given the growth and the amount of data in cloud, SaaS, interconnection platforms as a service, huge data lakes, it's an impossible task. So that would be my magic wand.
Justin, that's music to my ears, honestly, because that's exactly the approach that we've been talking about with the team a lot more, because people's ability to absorb multiple challenges that organizations are facing, right, is limited. We have to understand and appreciate that, and not everything can be around privacy. I think we're also a bit realistic, right? So I think that's a great tip, and thank you all for your wonderful suggestions again. I would like to introduce David Satola here. David, who's the lead counsel, technology and innovation, to bring a little bit of the bank's perspective on this. So David, welcome.
Good afternoon. Thank you very much. Delighted to be here. I have the improbable task of summarizing the bank's operational approach to these issues in 5 minutes. And so, uncharacteristically, I actually wrote it down last night, timed myself, and so I'm going to read it, which I ordinarily would not do, to fit within the 5 minutes. So let me set the stage a little bit. We've heard from others this morning that the data ecosystem in which we inhabit today is unrecognizable from what it was 5 years ago. We live in a world, as everyone here would acknowledge, that's dominated by data, and our personal data is an unimaginable miasma swirling around the globe that we're trying to control. Very difficult task. Within that context, there is a trend, I think, in data protection around the world that is one that's based on individual rights. It's a rights-based approach. The GDPR, which we heard about earlier today, was a first mover or a market leader in establishing these rights to protecting personal data. In the intervening 5 years, we've seen countries around the world adopting similar legislation. Just not off the top of my head because I have it written down here, but just a few examples of some recent laws that have been adopted: Sri Lanka, Brazil, Kenya, Rwanda, Panama, loads of others. We also know that China adopted a data protection law for the private sector that looks a lot more like GDPR than it doesn't, which would surprise a lot of people, I think. And we know that there are loads more countries who are about to adopt laws that look a lot like GDPR as well, and amongst those are Somalia, Ethiopia, and others. And then, as we've heard just now, closer to home, we have state laws from California, Colorado, and Virginia that are about to reset that landscape. Our 2021 World Development Report, called Data for Better Lives, situated this data protection issue as part of an evolving social contract around data, and that this fits into a trust framework that, we've talked about obliquely here today. How do we encourage people to participate in this global data economy? Do we give them how much trust do we give them in the system to make it work so that they do participate, and where do the limits to that exist? But the WDR did posit that the trust framework, the social contract, and the approach to data protection was a rights-based approach. The WDR also recognized that data protection alone is not sufficient, that it's part of itself a legal ecosystem, including e-commerce laws that govern the transactions that we do online, and cybersecurity and laws that combat cybercrime to assure the integrity of the infrastructure and the data. And that these in combination are integral to the economic development work that we do with our country members in order to encourage participation in the global economy. It's a bit abstract, so let me give you a couple thematic examples in the time remaining. First is our Digital Identity for Development program, ID4D. And it was the first initiative in the bank that I'm aware of that featured in its projects a very deliberate look at data protection. When ID4D started in 2015, which predates GDPR by a little bit, it was really driven by the Sustainable Development Goals, the SDGs. And the problem that we faced there was now we have a UN mandate, a global mandate from the member states saying, go forth and do digital ID. Didn't tell us how, didn't tell us what protections to put in place. We reckoned, as we got into this a little bit, that because it was digital, that allowed us to incorporate protections, technical protections that didn't exist in the analog world for analog-based ID. But we knew we were dealing with a lot of sensitive data, data of vulnerable groups. So we insisted that all of our ID4D projects in the intervening years, have been around 45 or so, include a robust due diligence on data protection, include components that would address gaps in legislation if they were found through the due diligence. And we issued at the same time something called the Principles on Identification for Sustainable Development, which were endorsed by 30 multi-stakeholder groups, countries, UN organizations, foundations, and NGOs as well. And we developed a legal due diligence tool called the IDEEA, ID Enabling Environment Assessment, that we use in every project. And then came COVID. And in what was perhaps the single biggest global exercise in data collection, possibly since the time of Caesar, the response to COVID in those early, very scary days required collecting and processing vast amounts of personal health data. I'm proud to say that in the dozens of countries where we provided financing, and in the millions, if not billions of dollars that were poured into the COVID response, the bank systematically took measures to ensure that all the personal data that was collected by our member states would be done in a context of minimal data collection if they didn't have a law in place, even in that emergency context. And I can tell you the internal debates about that were pretty hairy, and but in the end, it was recognized that that was the right thing to do. And eventually those same protections were extended when we started financing vaccines. But challenges do exist, and they include capacity building. We didn't really talk about that very much today, but capacity building around these new laws, around these institutions that are created by these laws, both for policymakers, legislators, judges, lawyers, civil society, NGOs, and people to understand how they relate to this ecosystem. Operationally, we do address data protection in our project due diligence. We have something in the World Bank called the project cycle, which is from project identification to appraisal to negotiation to implementation, and usually the project cycle takes anywhere from 5 to 7 years. So throughout the project cycle, we address these data protection issues through due diligence, designing project components that are fit for purpose for the country, and then through the supervision of the implementation of the project. In our advisory capacity, we work with our counterparts and with our internal task teams throughout the project cycle to make sure that the recipients can achieve their project development objectives within the context of protecting personal data. But let me leave you with this thought, and I'm nearly done. We know that Google is a search engine, but it's really a data company. And Facebook is a social network, but it's really a data company. Amazon, someone mentioned Amazon or a footwear company or something earlier. These are they are retail consumer online services, but really they're a data company. And my hope is that in the near future, the bank will embrace the fact that in addition to being an international financial organization, it's also a data organization. And with that, I thank you.
Thank you very much, David. I think there was one question from the online audience. You could choose to answer it later, but the question is, in what region has the World Bank been focusing on most when it comes to privacy and digital development projects, and why?
Well, very quickly, we have digital development operations, and therefore that include data protection components in all of the regions that we serve.
Thank you. I knew you would be very quick. So I want to really welcome Chris Stevens, who's our Senior Vice President and Group General Counsel for the World Bank Group. Chris, thank you very much for coming. Sorry we're late. You can choose to do it from there too. We have got Chris to do some closing remarks, and then I'll say a few words.
Thanks, Riaz. Good morning, good afternoon, depending on where you're participating from. We've reached the end of the program for the Data Privacy Academy segment of the Data Privacy Day 2023. We've had some terrific discussions that have touched upon how increasing digitalization and the development of technology are reshaping the data privacy landscape. And as Lakshmi said at the outset, how AI and machine learning are both impacting development and at the same time increasing risks to vulnerable populations and raising the stakes on issues of data privacy more generally. We've had the pleasure of hearing firsthand from global data privacy experts and World Bank Group senior management on the power that data has to boost new technology and indeed to shape the future of the bank. It occurred to me when I was sitting back there that, as many of you know, the bank senior management and the board are engaged in redefining the mission of the bank. So while we're talking and have been for the last 15 years about twin goals, there may be triplicate goals, the newest one delivering global public goods. And that involves the aggregation of all of the data and information we have into analyses. So we are, in fact, as David just suggested, becoming very much a data bank. And with that, we need to be mindful of the need to rigorously protect the privacy of vulnerable people and communities in developing countries. We've had some fascinating discussions that have also touched upon data privacy and how that intersects with the public trust in international institutions such as the World Bank. So I hope this event leaves all of us with plenty to think about, lots of ideas to reflect upon, and the importance of data privacy and how it can be, issues and risks can be identified, mitigated, and integrated into both the bank's operations and to our own everyday lives. Professor, it would seem that privacy is not dead. So this annual flagship event is a great opportunity for us to come together and build and expand our network of data protection and data privacy experts, and to learn from each other and to deepen our awareness of the importance of data privacy, programs to identify risks, programs to mitigate those risks, and the importance of compliance and training to stay on top of this ever-changing area. The event's also an opportunity for compiling the organization's experience and expertise in areas of strategic importance, drawing from important lessons learned and honing them into innovative and practical solutions to address risks and enhance compliance. So I'd like to thank all of our distinguished speakers, both who participated in person and virtually. That participation really has been the key to delivering a successful event. I'd also like to thank the Data Privacy Office for organizing this terrific event, and Teach Privacy and Professor Soloff again for co-organizing the Privacy Academy for the second consecutive year. Thank you, Professor. In an era of multiple overlapping crises, it's important that well-positioned international organizations such as the World Bank exercise our convening power to continue conversations for the benefit of the millions of people who have placed their trust in our organization. And finally, thanks to all of you for participating. We look forward to your feedback. Please enjoy the lunchtime talk with Professor Ryan Calo that follows this segment. And with that, Riaz, I'll turn the mic back to you, and thank you for chairing this segment.
Thank you. Thank you, Chris. Thank you, everyone, for being here today. I just want to personally thank Arune Madhar and her team for organizing this event. As you know, a lot of organization goes behind such a day. Everyone online, for staying with us, I hope, for most of the half a day. And of course, to all of the panelists who have been really, really insightful, and Dan himself. So I think lunch is out there with some lunch boxes. Please feel free to grab that. And then I think come back in 10 minutes or so when there will be another session hosted by Ryan Calo, as Chris mentioned. So take care. Have a good day. Bye.
Hello, everyone. My name is Vivian Arts, and I'm a Data Strategy and Privacy Policy Advisor to the Center for Information Policy Leadership. CIPL was established in 2001 as a global privacy and data policy think and do tank based in Washington, D.C., Brussels, and London, where I am. CIPL works with industry leaders, regulatory authorities, and policymakers to develop global solutions and best practices for privacy and responsible use of data. Thank you for inviting me to speak today at the World Bank Data Privacy Day in 2023. Well, for privacy professionals, we know that data privacy and data protection are far more than legal and compliance issues, or risks to be identified and managed, and processes and procedures to operationalize. We look at privacy and data governance through many lenses, whether contractual obligations, customer expectations, strategic objectives, as well as regulatory obligations. We know that privacy and data protection needs to be part of how an organization handles its data, from creating or receiving data, to innovating and sharing data, to respecting data rights, and finally storing and deleting data. When privacy and data protection are part of how the fabric of an organization operates, then compliance is embedded. And when we embed privacy in an organization's systems, processes, technologies, and organizational culture, we have a structure and organization that protects privacy by default and enables the use of data to its fullest potential. Privacy is then no longer an extra step, a hurdle, a necessary bureaucracy, but instead is part of the ethics and ethos of how an organization holds and handles data. A culture of privacy is one which respects data and those to whom it relates. It handles data securely. It ensures that data is up to date and accurate, that it is shared and used as expected, and is transparent about its use. It is also an organization which is then able to realize the value of data and to understand the strategic opportunities that data can facilitate. We should all be aiming for a culture of privacy in our organizations. We are seeing a number of best practices evolving across the private sector and government to better manage data privacy risks. But what do these look like? In the private sector organizations, we're seeing data becoming a board issue. Boards are interested. They understand the importance of data as a strategic asset for businesses. We also see the elevation of data to the C-suite. The C-suites or the executive group are increasingly understanding the importance of data, and we're seeing reporting lines change as well. Think about the rise of the Chief Data Officer, the Chief Privacy Officer, the Chief Information Security Officer, data governance officers, and data strategy officers. We're also seeing the evolution of ethics committees, very often focusing on artificial intelligence. And all of these innovations demonstrate that data privacy is elevated to much higher levels in the organization where strategy and decision-making take place. We're also seeing increased awareness amongst people within organizations. Better awareness and transparency about how we treat data is being perceived as a positive rather than a negative. There's a greater understanding that responsibility for good data practices is something that is the responsibility of every member of staff, not just a particular department. Mutual responsibility is key. And organizations understand the importance of their approach to data as being at one with their credibility as an organization. On the technology side, we're seeing an enormous amount of privacy tech innovation, not just to track and manage compliance and reporting, but to further privacy protections, whether through encryption or other innovations. We're also seeing new generations being involved. The focus on children's data, legislation in the Americas as well as in Europe on children's data is increasing. Our younger generations will understand the responsibilities and rights that go with data. And at the government level, we're seeing more cross-regulatory cooperation. For example, in the UK, we have the Data Regulators Cooperation Forum, and in the Netherlands, we have a very similar organization where a number of different regulators have come together to understand the importance of data as the thread which draws those different regulatory responsibilities together. And by collaborating and cooperating, they can ensure coherent regulation going forward. We also see Japan's initiative in the G7 with data free flow with trust, the recently published OECD Principles for Government Access to Data, and an increased focus on the importance of data in trade. So at every level of our society, our people, our companies, and our government, new initiatives to support better data practices for us all. Thank you.
Good morning, good afternoon, and good evening. My name is Vincent Cassard, and I am the head of Data Protection Office at the International Committee of the Red Cross. I'd like to highlight two major data protection or privacy risks that we see in humanitarian action and link them with three challenges that I hope we can discuss and make progress on at the World Bank Privacy Day. The first thing we need to underline is that in humanitarian action, the potential misuse of personal data represents a real risk for the safety, for the integrity of individuals or groups in vulnerable situations. Let's take an example. A family who wants to get in contact with a son who has been arrested and detained under the accusation of being part of an illegal armed group. The family will need to share enough information about themselves, about their detained son, to receive news and to contact him. However, should this information fall into the wrong hands, they could be singled out as affiliated to the said armed group, they could be discriminated against and even arrested or otherwise hurt. The second major risk in processing personal data in humanitarian action is the fact that our capacity to operate depends on trust we can build with all people living in humanitarian crisis. So the victims, the authorities, armed groups, and other stakeholders alike. Everybody needs to know that what we expect of the ICRC, that what we do is only and solely meant to help affected populations. So when data collected for humanitarian purpose is accessed and used for non-humanitarian purposes, it breaks this trust of the people who share them. And in turn, it can mean that our capacity to fulfill our mandate to protect and assist people, as well as the security of our staff on the field, is compromised. So now, how can we mitigate these data protection risks in humanitarian action? First, we have developed a strong data protection framework that guides the ICRC digital transformation. So it was developed in dialogue and partnership with humanitarian actors, academics, the tech sector, and governments, data protection and privacy authorities. We have addressed the challenge of responsible use of technology for humanitarian actors, and you can find our recommendation in the handbook on data protection in humanitarian action. This year, we are happy that a new version will be published that includes a new chapter, notably on data protection by design and by default, and elements on government access to cloud services. The second challenge is linked to cybersecurity. The attack that affected some ICRC servers in 2022 was a striking reminder of the importance of securing personal data. In response to the attack, we have implemented strong measures to upgrade ICRC security posture, and we continue working on it. But to mitigate this risk further and to prepare for potential information security incidents, ICRC is working on developing frameworks and good practices that combine both cybersecurity and an enhanced protection of the personal data of individuals. So in other words, a strong data protection by design and by default framework. And this challenge is to integrate these different elements to basically include data protection perspective in the traditional cybersecurity management as it increases our security posture. Finally, a challenge that is illustrated in recent conflict, notably in Ukraine, how can humanitarian organizations keep a neutral, impartial, and independent stance in humanitarian action? The current digital environment is bringing multiple challenges to the trust we need to keep to access the affected population. We basically rely on digital tools for delivery of services more and more, and beyond just a vendor lock-in issue, ICRC neutrality or perceived neutrality is put into question because tech companies are becoming openly politicized in this environment. So the question is, how can the humanitarian sector implement due diligence in the use of technology? To tackle this risk, we have opened at the beginning of the year in Luxembourg a delegation for cyberspace that is meant to be a testing ground to explore these questions. So to conclude, I would like to thank the World Bank for this fantastic opportunity and I'm really looking forward to the dialogue that will contribute to privacy and data protection issues in humanitarian action. It's clearly a key element for us, these partnerships and dialogue, to ensure that humanitarian organizations can protect their capacity to work in a more and more digitalized environment.
Okay, hello everybody. I hope you're settling down with a lunch, and for those who are virtual, perhaps breakfast or dinner, depending on your time zone. Thanks for joining us. I am Dave Sullivan. I'm Deputy General Counsel for Institutional Affairs at the World Bank. And I'll just say it's bittersweet to be wrapping up such a packed event. We've heard from Dan Solove about the dynamic and ever-shifting state of privacy across the globe and how we got here. We've heard from David Satola on the bank's approach to privacy and the unique stakeholders, work streams, and missions that inform it. And our panelists have covered everything from hidden complexities of consumer-side AI tools to effective operational privacy compliance across large institutions like our own. Now I'd like to close the Data Privacy Day by introducing their speaker for our lunchtime talk, Mr. Ryan Calo. Ryan's a professor of law at University of Washington, as well as a founding co-director of their multidisciplinary UW Tech Policy Lab. Ryan writes extensively on law and emerging technology, including in the nation's leading law reviews and technical publications. Ryan also chairs our very own external expert review panel at the bank, which is one of our key components of our privacy policy to provide redress, both internal and external, for data subjects. And he exercises the required impartial and detached eye of one of our panelists. So Ryan's talk today is entitled Privacy and Vulnerability. And Ryan, thanks for coming, and over to you.
Absolutely. Thank you so much for the introduction. Thanks for all of you who stuck around, all of you online, everything else. I am, of course, speaking in my own personal capacity as a law professor today. So when I started working in the field of privacy, now according to Dan, we're in the Middle Ages, so I think I started in classical antiquity was when I first started working in privacy. I don't know where that places you, Dan, but so when I first started working in privacy, the conversation was very much about control over personal information. Did you have control over your own personal information, right? And that conversation over the years has really morphed into a conversation that's more about what kind of control can others exert over you by virtue of the information that they have. What Dan said earlier about privacy being about power. That's been a deep shift in the conversation about information privacy over the years that I've been working in this. I see other longtime participants nodding, and so that's what my remarks are going to be largely about today. You know, what does it mean to be? What does privacy mean for one's susceptibility to control and to harm? Okay, so. I have a couple of school-aged children, and one of the things that they always try to get me to do is to come up with like a murder mystery that they can solve. This is extraordinarily difficult. I don't know if anyone's ever tried to come up with a murder mystery before. It's real hard, you know? And so I have a bunch of go-tos. One of them, of course, is that the weapon was ice. That really always gets them every time, right? But another one is that there's an allergy. That's the other way that this murder mystery often works. And it occurs to me that, you know, when you have an allergy to something, especially a deadly allergy, you are very vulnerable. All of a sudden, somebody who has knowledge about you can end your life with a store-bought cookie, for example. And so this is a very simple way in which knowledge about you is a form of control and a form of vulnerability. Now, the way that the law intersects roughly with vulnerability has historically been the idea that there are certain people by virtue of their status or their relationship who are vulnerable persons. The idea being essentially that, you know, if you're older or you're much younger or you have a certain kind of disability, that you're vulnerable. Or if you stand in a particular relation, that between a patient and a doctor or a client and a lawyer, that you're vulnerable in that context. But the way that I think about vulnerability, and I think a lot of the literature thinks about it, is more in the sense of Florencia Luna's idea that vulnerability is a kind of a state that you're in, or a layer of your personhood. And some of the really important aspects of that mean, first of all, we shouldn't really be thinking about vulnerable individuals. We should be thinking about the fact that all of us are at times vulnerable in particular ways. And also, we shouldn't be thinking about vulnerability as some kind of status that we carry with us all the time somehow, but rather we should understand that we can be rendered vulnerable. And indeed, a lot of effort is placed into rendering people vulnerable. And I want you to consider, for example, the commercial context. So we talked about behavioral advertising today, we talked about consumer privacy. But I want you to consider the difference between the following. A company charges $9.99 for everything because it feels further away to you from $10 than it really is. That's why everything costs $9.99, right? They're trying to extract that surplus. So imagine the difference between that and figuring out what the reservation price of your consumer is. That means that's the most that they're willing to pay. If you can figure out someone's reservation price, you can charge this person over here $9, you can charge this person $12. You can charge this person who's really desperate because they just watched a sad movie or had a breakup or are intoxicated, whatever happens to be, even more money, right? And so this idea is, and this is something that many companies are working on very hard, how do we figure out how to get at a person's highest amount that they'd pay and thereby extract the most out of them that is possible? Now, of course, this event is hosted by the World Bank, and this is an institution that has a mission of promoting global economic development and lifting people out of poverty, right? So we're not talking about a commercial venture here. We're talking about a global effort to ameliorate the lives of millions and billions of people. And this is, information is, of course, absolutely critical to that mission. And we heard, earlier from Christopher just how much of a pivot even that the World Bank is making toward even more engagement with data, even more of a centrality of data. But at the same time, while it is critically important to gather information about the individuals that you're serving and the context in which they operate, there is also a lot of concern and danger around there. So I just wanted to give a couple of examples in very recent memory, the last couple of years, where very well-meaning, for lack of a better word, surveillance structures ended up rendering people much more vulnerable in a way that was not intended. So one example is the Rohingya. So these were UN refugees in Bangladeshi camps. They were rendered vulnerable when, a couple of years ago, Bangladesh apparently shared biometric information that they had gathered to try to service this group of refugees back with Myanmar, the very government that they were fleeing from. And that was sort of viewed as a situation where a very well-meaning effort to try to identify and categorize a group of vulnerable people rendered them extremely much more vulnerable. Another example is Afghanistan. So Western governments and international institutions in Afghanistan, when they left in, again, 2021, they left behind digital identity and payroll systems that had Afghans' personal information, biometric data, iris scans, fingerprints, photographs, occupation, and everything else, and the names of relatives. And then currently, even now, those databases are in the control of the Taliban, which is reportedly looking for ways to leverage them. Right? So I want to recognize, of course, that the powerful community around the World Bank cannot meet its collective goals without gathering information and promoting the free flow of information across various borders, right? But that at the same time, these kinds of efforts have the capability of backfiring without adequate care. And one of the places that I want to highlight is not necessarily in the, management of refugees or something along those lines, but in standing up welfare systems, social safety nets. Right? So critical to lifting people out of poverty is not only economic investment, but having adequate economic and other social safety net below them. And we're in a phenomenon that we're seeing in the United States, and we're also seeing globally, a lot of those systems are incredibly information intense. And so, a few years ago, the UN Special Rapporteur on Extreme Poverty raised alarms around the risks of adopting these digital welfare systems, talking about how while they had, of course, very well-meaning aspirations, in actual point of fact, they were eliminating services resources. They were demanding intrusive forms of conditionality. They were being leveraged in pursuit of behavioral modification goals that people thought were questionable. All of this, you can read this in this long October report. But the basic idea was we're trying to use limited resources, and we're trying to use software, automation, and information in order to be a support structure, but in point of fact rendering people more vulnerable. Another example is a report that from just very recently in 2022 by Privacy International that went through a bunch of different social safety net projects that, of course, were funded by large multinational organizations during the pandemic, and concluded that they can inadvertently lead to excessive surveillance of marginalized communities and impact equal access to urgent social production disbursement and interfere with dignity and privacy. So, the basic point, and I'm hoping this can be very much a conversation among us, is that while no one could deny the utility of knowing a lot about the populations that you serve, about being able to verify their identity, authenticate that they are who they are, understanding better the context in which you operate, there is this real danger that you are setting up what Dan referred to as early as 2003 as an architecture of vulnerability. As organizations like the World Bank and those that maybe you work with, if not that organization, need to be attending not only to the kinds of mechanisms that secure personal information and secure control over personal information, make sure that it's safe from being hacked, make certain, these kinds of things, but deep thinking at the outset, to echo the panel just now, about whether or not you are simultaneously rendering these populations vulnerable. Because my position, it's idiosyncratic to me, but it seems defensible, is that ultimately lifting people out of poverty and engaging in a mission certainly of bringing public goods, it's about promoting human flourishing, right? And when people don't have the dignity that comes with privacy, when they're rendered more vulnerable by the very mechanisms that you're using to support them, you're undermining that mission. And so the question is, how do you set up these kinds of structures in ways that not only have formal controls over where information goes and how it's analyzed and whether you're collecting the minimum amount, but are you, in setting up these structures, respecting people's deep dignity, and are you rendering them more vulnerable, right? And I think that's going to be a critically important question as we go forward, especially with organizations like the World Bank that are beginning to try to layer in an explicitly, I think, public goods or public interest layer to what they're doing. So rather than take up too much time, and I know some of you have told me you have to run, I'm just going to stop there and hopefully we can get into the Q&A. But thank you so much for inviting me, and I really appreciate it. And I've also really enjoyed serving in this capacity as an external reviewer.
Thanks, Ryan. That's great. And I'd like to make sure that folks online have the ability to put questions into Ryan. Just pop them in and they will pop up with me. And then, of course, anybody here as well. But this is meant to be sort of a conversation. And I think I'll just kick us off, which is you heard Chris Stevens and David Satola. David, you put it very nicely. And if you want, please come up because you're our operational policy guy. Okay. To talk about the bank being a data bank. I mean, Amazon a data company, Google a data company, and the bank being a data bank. And yes, there is recognition, I think, in our evolution thinking that this is perhaps something that we should be working on more actively in the way that we produce data products and support the development of certain global public goods. But it's been with us all the time, right? I mean, our projects fundamentally rely on the collection and storage and dissemination, frankly, within governments of personal data. And as you have written quite eloquently, among the wealthy, data privacy may be a luxury good, if you will, or others have looked at this, but among the vulnerable, you are extremely vulnerable because in order to access government services, you're kicking out a lot of data that others may not be doing because they're not accessing the same service. So, we're in the mission of eradicating poverty. And in the middle of that, we work with many of those who have to access services to lift themselves up. And as you say, vulnerability is fundamental and one of the compromises that happens in our projects. So thinking about this, what advice do you have? I think there are probably folks online from other international institutions. The bank was sort of a leader in coming out with a privacy policy and aggressively and affirmatively thinking about privacy regulation internally, since we're not a regulated entity, through all of our projects. But privacy concerns exist irrespective of whether there is a policy or whether we look to external regulation as a guidepost for our own internal regulation. But what advice do you have for other international institutions that may be watching here to think through how they incorporate privacy into their own operations?
Yeah, sure. I mean, so first of all, an interesting intersection between privacy and vulnerability is that a lot of exploitation and abuse of marginalized, powerless people has happened behind the veil of privacy. And so within the privacy literature, you see references to the way in which intransparency or a reticence by government to get involved in, for example, family life, has actually empowered actors to hide behind privacy in order to do things that really should have come to the light of day, right? And I see a similar tension playing out here, which is that, of course, while you want to respect the privacy of the communities that you're serving, you as an organization also want to be as transparent as you possibly can be. You don't want your own, claims of privacy to shield you from the kind of accountability that people will expect. In some ways, you might think about the World Bank or other kinds of multilateral institutions as not being subject to any particular set of laws. You're not signatories to any treaties. You're not beholden to any particular sets of laws. But in that sense, as we've heard today, you're not really so differently positioned than a lot of American companies. That is to say, yes, it's true that you might have the possibility of FTC enforcement under a very broadly worded act, for example, or that in particular domains, working with particular populations or in particular sectors, you might have to respond to privacy laws. But ultimately, a lot of what you're doing as an American company is, trying to just do right by your consumers, but also avoid the kind of scrutiny that would come with really stepping over that line. And I think that multilateral institutions, first of all, for their own credibility and efficacy in the world, even if they're not subject to particular data protection regimes, need to be very, in many ways, like sort of, I think we heard a reference to Caesar already, but like Caesar's wife, above suspicion. I mean, you have to model the kinds of practices that you see as best practice in the world to maintain that credibility. But at the extreme, if you're using your multilateral, multinational status as some way to avoid the kinds of requirements that other operators are doing, it's not beyond the power of the law to begin to reach you. You know what I mean? And so there's also that sort of Damocles. But I think that the most important driver for being so careful around data protection, privacy, and these other values is to maintain your reputation as a accountable, a beneficial operator in this space.
And to build on that, perhaps, I mean, we wouldn't and we don't lose our, we're not cognizant of our role in terms of being able to drive policy through the way that we provide financing to countries, as well as the way in which we undertake particular bank finance activities that have privacy outcomes.
Yeah, I mean that's actually a really important point, which is that the ways in which multinational institutions operate in the world, part of them is things that you actually do yourself, missions that you undertake. You're on the ground, you're helping out. But there's also what you fund, right? And some of the examples that I gave that were thought to be problematic were not necessarily carried out by any particular organization, but they were funded from it, right? And so in tech policy generally, but certainly also in this global investment environment, the notion of procurement and investment is a very powerful thing, right? So the government can, in some ways, police the market by insisting upon only purchasing things that have values that are consonant with the public interest. A simple example might be only buying electric vehicles as the federal government to promote to promote the market in more sustainable transportation, right? And here too, when you're thinking about investing in a particular effort or activity within a community, insist on the very same values to which you would hold yourself as an organization.
We have some online questions, and let me just first open up to any questions in the room before I go there.
So thanks, Professor Kello. So you referenced the Rohingya issue in Myanmar, and I think one of the bigger concerns there is that the refugees were claiming that they were not provided notice and they didn't consent. Because here at the World Bank, if we don't know who needs help, we can't provide help. So identification is key. And in the case of Bangladesh, the data had to go because they wanted to know the type of people that they're dealing with. So besides providing general notice and consent, are there other practical ways in which those refugees' identity or information can be protected?
I mean, so we've heard about how notice and consent is not a terribly effective mechanism, even among, American consumers, much less a population that's been displaced by, and so I don't know that simply informing them that this is going to happen would of course, and nor do I take you to be suggesting that. Rather, can you design these systems in such a way that it is very difficult to repurpose them for some problematic instance? So, for example, would there have been a way to design these digital identity and payroll systems in Afghanistan, anticipating the prospect that perhaps a less benign, at least vis-a-vis some of the population, would come to inherit them, right? And so I think that I understand that you do need to know a lot about people that you serve. I wrote this paper once years ago that was sort of cheekily entitled Privacy and Markets, a Love Story. And the basic idea is that in an open market, you can basically trade goods and services based only on a couple of important data points, like what is the person willing to pay, what is the quality of the good, and so on. But if you're going to disseminate resources to vulnerable people, you really need to, if you're going to figure out to each their own, you need to know a lot about those populations, right? So the question is, can we design these systems in such a way that they would be vanishingly difficult to repurpose? I mean, I think that, again, I'm not deeply familiar with the context in Bangladesh, but the criticism, of course, has been that biometric information, while critically important to one government, did not need to be shared back, right, with that other one, and it was apparently in a format where that sharing was actually possible. And so the idea would be that as you are designing systems that are meant to serve these particular populations, how do you do so in a way that minimizes the prospect of reuse and weaponization?
Thank you.
Yeah.
As well as other limitations on use on overly broad protection, I would assume.
Yeah.
I mean, not protection, but overly broad collection.
Yeah, I mean, we do have a number of different standards available that we can apply. Some of them are encoded in the architecture of the system, and other ones are protections that we're very familiar with, having to do with additional layers of requirements around reuse and data minimization and the like. Yeah.
Super. Others, sorry.
Hi, I'm an assistant professor in the School of Business of George Washington University. So I want to get your opinion on privacy-enhancing technologies. For example, currently we have Google Sandbox ongoing, and Google is going to end third-party cookies at the end of this year. And also consumers can use ad blockers and anti-tracking devices when they go on internet to avoid digital advertising. So I'm wondering, what's your view on this? Because this is not a government view, this is not regulation, this is purely about self-regulatory behavior to avoid, to protect their privacy. So any feedback will be important.
Absolutely. I mean, so there is a community around both academic and also within industry and elsewhere that is dedicated to trying to come up with these design ideas that are ultimately protective. And indeed, at the University of Washington, where I work, I have colleagues in computer science that are working specifically on how do we design privacy-enhancing technologies for particular marginalized communities, including refugees. Was one of the areas, and so what I would say is that it's a wonderful development. There are entire conferences devoted to it. It's a way to achieve some of the goals that we all want without necessarily having the legal requirement in place, and it's also something that can be a competitive differentiator. I mean, that's one of the other things that's really been an incredible development over the last 5 or 10 years is that really the ability to have privacy has driven market decisions, and people actually choose to use this thing versus this other thing. And that's especially true of people who are have very legitimate reason to be concerned about them. So whether they're journalists operating abroad or and so on. So I'd say first of all that it's important. I think that to channel Alvaro, to the commissioner, I don't think it could be enough on its own. I did get a little bit worried with the ascendance of the privacy by design movement, worrying a little bit about whether it was supposed to supplant actual legal requirements and regulations. I think you need both. But funding, incentivizing, celebrating privacy-enhancing technologies that could serve some of the purposes of protecting the marginalized while realizing the goals is of course a wonderful development. Is that something that you're working on right now with? Yeah, hasn't it been fascinating to see like DuckDuckGo and to see the way that people may be choosing this phone over this phone for privacy reasons, advertising about privacy, critiquing other competitors over privacy? That really wasn't happening really all that long ago, and yet so that's encouraging, right? But in the international development context, you don't have those kinds of economic incentives, so we can't rely purely upon consumer-driven decisions. But there are other excellent reasons to be investing in how do we design privacy-enhancing technologies. I do believe, though, you have to do what my colleagues do. You have to get on the ground. You're a journalist operating in this jurisdiction, wherever you're operating. What kinds of problems do you have to solve? So, because it really changes things. For example, with journalists, they want to protect their identity and they want to protect the identity of their sources, but they also need ways to independently verify that those folks are who they say they are. Otherwise, they can't go to print with the story, right? And that challenge is, it's not completely unique to journalism, but it requires different affordances for that privacy-enhancing technology for that population. So there's no one-size-fits-all. Similarly, with refugees, they have particular concerns, one of which is that their information will be shared back with the very government that they might be fleeing from. But it's a vibrant area of research and a very worthwhile one.
So to some of the online questions, can you comment on the link between civil rights, human rights, and the right to privacy?
Oh my goodness.
Quite a large question, but there you have it.
It'll be about 45 minutes for those of you who have. No, Dan had to go teach, and but he and I have gone back often back and forth often about what is unique about privacy, right? And to me, privacy is very much about observation. And so if you have a phenomenon, say misinformation or whatever it happens to be, discrimination writ large, but I'll get back to that in a moment, then it's not necessarily a privacy problem. So certainly not all civil rights issues are privacy problems. That said, in a world that is increasingly mediated, where so many decisions are made on the basis of data that's gathered about people, then that observation becomes a component of so many different kinds of other issues, right? And so contemporary human rights violations nearly always implicate privacy for some of the same reasons that so many different, multinational organizations or companies or whomever are increasingly datafied and data intense. And so I think of privacy as being itself a fundamental human right, but I also see privacy as implicated in the prosecution of all other civil rights today. Not analytically necessarily, but just by virtue of the fact that so much is happening against this backdrop of an information promiscuous environment. So that's a shorter answer to a very difficult question.
A very big question on which you could teach a course, no doubt.
Yes, yes.
So another question on the enormity of data collection, getting our hands around this. One person online is noting that many organizations don't really have a handle on the scope of the data that they collect. And given the enormity of collection, how do they deal with data protection and privacy issues when different components of the organization are collecting and there's no sort of centralized processing for this? How do they get their hands around all of it?
Yeah, so it's funny because in the early days of the internet, when you started to have these enormously scaled up platforms and things like that, right? You'd often hear folks say, well, I can't really be responsible for what happens on this platform because there's just too many people on it, right? I can't possibly police all of this different stuff. Yes, I could if this were just a hotel. I could make sure there's no drugs being dealt here, right? But I can't. This is Craigslist or this is whatever it is. And for a time that I think it was a very attractive argument and it helped protect these platforms against an intervention. But eventually, we sort of came to think to ourselves that some people came to think to themselves, like, maybe these platforms shouldn't be quite as big as they are if they can't police their own content, right? And I have a similar response to this question, right? If your organization is so big and so complicated that you really cannot get a handle on the information that you have, one wonders whether you should be collecting all that information, right? I mean, really, why are we not requiring these organizations to bite off what they can actually chew? And so I think there's increasing frustration, at least in the United States tech policy, around the idea of throwing up your hands and being like, I'm sorry, there's just a lot of stuff out there, right? It's like, yes, but you created this. You're the one who gathered the information. You're the one who built a platform that's supposed to reach millions and millions of people. So I don't know. I mean, I think that you collect the amount of information that your architecture and personnel is capable of getting a handle on. And if you find yourself chronically in a situation as an organization where you don't have a sense of what data you have and you don't know where it's flowing, that is a gut check for you that perhaps you're biting off more than you can chew, is my view.
I don't know where that question came from, but given that we have many multilateral financial institutions that are potentially participating, all of whom have relationships with governments, all of whom have programs that go far and wide, it's not an unusual sentiment, I would think.
Yeah, I mean, and I mean, I understand that sometimes it needs to be done, but then you have to have adequate investment that is up to the task of getting a sense of that. Just the idea is it's too complicated, can't be an answer anymore.
So there's another theme coming on harm, which is, can you talk about any studies that talk about the effect of privacy violations on individuals or that exist or that are coming out? And important, about your thoughts on assessment of privacy harm and how institutions should be thinking about the impact of privacy violations.
Yeah, I mean, so there's a sort of cottage industry among privacy academics of talking about harm and evidencing harm and the like. And there are specifically studies that go to particular aspects of harm, like its effects on of a lack of privacy on creativity or these kinds of things. I have a paper that I wrote about the nature of privacy harm. That's the one that Dan and I disagree on. And basically, I've thought about privacy harm as having one of two aspects. Either there's the harm from the perception of unwanted observation. So this is the idea that you just feel surveilled. You feel you're living under conditions where your self-actualization, your willingness to experiment, your everyday lived experience is under the shadow of surveillance. One of the phenomenons that has been so interesting in recent years is, I don't know if anyone's had a conversation with a friend where they're convinced that they were talking to somebody else about some topic, and something around their environment, smart speaker, phone, whatever it was, picked up on it, and then when they went online later, they got advertised that exact same thing, right? Kashmir Hill at the New York Times did a whole story about this. This idea that like you could believe anything, but you believe it's possible that your private conversation with your friend can then later be reflected in your internet advertising, even if that's technically not possible. Why do people feel that way today? Because of the conversation we just had about going by a billboard and then later seeing that billboard. In fact, some of the things are technically very possible. And it's an uncomfortable feeling to think that at any time anything you say could be leveraged for this commercial purpose, right? Let alone if you feel like you're being monitored by a totalitarian government and what possibilities that creates for free thought and so on. So that's one set of harms. And then the other set of harms is really when information about you is used against you to affect you negatively in a material way, right? And that is everything from you being charged a higher price because the company discovered that you have a higher reservation price and hence you pay more than other people for something. Or any of the myriad other things that we talked about throughout the day about not getting a job or being fired from it or not advancing, having this or that worse outcome. So when I think about how to inventory the harms you have within the organization and how to evidence them, I tend to encourage people to think about both of those elements, right? Are you creating an environment that is making people perceive that this uncomfortable feeling of being monitored that then affects various aspects of their psychology and their life, and are you creating opportunities to use people's information against them? But if people want to get in touch with me afterwards about specific studies that are evidencing the harm of this or that, I'm happy to do that.
There's a related question related to your early article, one of your early articles, that talk about Paul Ohm's database of ruin, which is that everyone has a fact about them that if disclosed could be ruinous, right? So thoughts about that catastrophic harm and how that impacts the way that we should be thinking about privacy or others should be thinking about privacy in the way that they carry out their corporate work.
Yeah, so Paul Ohm's concept of the database of ruin is essentially this idea that it's meant to push back against the notion that you shouldn't worry about privacy because you have nothing to hide, right? Because for a period of time, and I don't think many people argue this anymore, but for a period of time, that was a very attractive, if specious argument. The idea that I don't need to really be worried about it, right? I think that Edward Snowden at one point made a quip that saying that you don't care about you don't have to care about privacy because there's nothing to hide is like saying that you don't care about free speech because you have nothing to say, right? But at the end of the day, what Paul was trying to point out was if you really sit down and think about it, for every person, everybody, there is a situation where if you were to link this to this and reveal an insight and reveal it to this particular person, right? It may be something that everybody would frown upon, or it may be something that just your parent would frown upon, right? But to the right person at the right time, revealing the right linkages of information is going to be ruinous to you, right? And I think that I think what that helps us reminded of is that you may be operating on your own and have the information that you have, but that information is going to be linked to other information as you engage in partnerships, as you increase the variety of activities that you do. And I think that Paul's insight is that, first of all, everyone should care about privacy. But second of all, you need to be attendant to the ways in which information about people can be compared to other things and create linkages that are unexpected and ultimately potentially ruinous. There's a silly joke in privacy. I don't wonder if I should tell it, but anyway, I'll tell it. Why not? It's at the end of the day here. Just joke being that people are at a cocktail party, and they come across there's a priest there, and someone asks the priest, like, oh, goodness, what is it like to hear people's confessions all the time? You know what I mean? And the priest says, oh, it's really wild. You know, it's like when I first was a priest, somebody, you know, the first person that ever came to me, they confessed to being a murderer, and everyone goes, oh my goodness, I can't believe it. Then some other guest comes by, and he said, oh my goodness, Pastor so-and-so, I can't believe you're at this party. I didn't know, know the news people. And then they say, well, how do you know him? And he goes, oh, well, I was his first confession. You know what I mean? I mean, the pastor's not trying to reveal any information about this individual, but that sort of linkages creates this ruinous situation.
Super. Just a couple more. Davos was all the rage talking about new AI tools and emails being written by ChatGPT. What are your thoughts on that and these new tools and its impact on the privacy thinking?
Yeah, I mean, ChatGPT and also the DALL-E system out of OpenAI and some of these other ones, as a person who's long studied technology and artificial intelligence and robotics in particular, this set of tools is the first set of tools where I just looked at it and said, wow, yeah, this is going to be a real game changer. However, whatever you think is happening, whatever you believe is happening on the back end, whatever sophistication you ascribe to it, I have a friend who is a doctor who is using that, ChatGPT in order to write letters to an insurance company justifying a procedure he wants to do. I mean, there's myriad. Obviously, he reviews it afterwards, but he just says, "Hey, I have a patient with these characteristics. I'm thinking about doing this procedure." Write a letter to an insurance company with scientific evidence, justifying the procedure, and the thing spits it out, and he doesn't have to, and he spends more time with the patient, right? And then he goes and edits it to make sure it's not wacky. And that's how he's using it. I mean, and there's so many possibilities. So I think that there's a lot of concerns. There's a lot of possibilities for harm. But with artificial intelligence, I don't think we've reconciled even with the non-generative pattern recognition aspects of artificial intelligence. Because the thing that is so interesting about artificial intelligence for privacy is that AI is increasingly capable of deriving the intimate from the available. Meaning that you may be shedding information all the time that seems innocuous to you, but maybe alone, maybe in combination, these powerful pattern recognition tools are able to derive insights about you that you may not want to reveal. You may be perfectly comfortable watching people, having people watch you shop at Whole Foods, and you might be comfortable doing this or that or walking, but if certain very private things could be inferred from those. And what's so destabilizing about the ability to derive the intimate from the available is that so many laws, internationally and domestically, are premised on these categories of being personal information versus not, or sensitive versus not. But increasingly, these powerful tools are able to infer sensitive categories of information from non-sensitive content, re-identify you on the basis of things that you wouldn't think would be personally identified information. And I think that's deeply threatening to the way that we do privacy law today. These other tools, while compelling and have their dangers, right? I don't even think they really represent the same kind of sea change. It is conceivable that it will be easier to look stuff up with this kind of interface. You do worry about the kinds of guardrails around data collection and scraping that would happen, sure, right? But I think the deep concern about AI and privacy is this ability to infer.
Your commentary on your doctor friend using ChatGPT to communicate with insurance companies strikes home. I'm thinking of myself as an international lawyer using Google Translate to translate a treaty and to think about, how do you edit out the wacky, right?
Yeah,
So,
yeah. No, it's non-trivial, and ultimately, just like with my friend, like it's on you. Like it's on you, right? I mean, you can't just hand it in and then just be like, I can't believe Google did that, right? I mean, it's on you. And I think one of the tricky things about artificial intelligence and robotics is it makes a kind of a shell game of responsibility, right? There's you're not really sure who, is it you using the system? Is it the people that built the system? Is it the folks that trained it? And it opens up the possibility you can point the finger at anyone else. But the responsible thing to do is to say, I'm the one who's responsible for this, and I need to make sure that the translation is accurate and I catch the wrong things. Yeah.
So last online question is sort of a wrap-up one for those that may be on here. Given that a lot of employees of MDBs are watching this, many of whom are likely operational and in the field, what general advice do you have for them to be more cognizant of projects that may introduce vulnerability?
Yeah, I mean, so that's a very good but also very involved question. I mean, so I want to associate myself with Heather's remarks about making sure to be foregrounding privacy, security, data protection at the earliest available stage. Once you're already deployed with a set of tools and a set of expectations, it can be very difficult to course correct, right? I think another important element of it is as you are designing these systems, make sure that you are in conversation with people whose lived experience will be materially affected, right? I think a lot of design of technology and technology policy, frankly, happens among a particular highly educated, rarefied, mainstream, often safe group of people that may be thinking, they may be quite thoughtful and interested and motivated in order to protect others, but their lived experience doesn't allow them to see some of these vulnerabilities. That's why when I'm talking about my colleagues building privacy-enhancing technologies for refugees, that they physically travel to these camps, these locations, and ask folks what they're actually worried about and what does their life look like and that kind of thing. So I would say, start early at the design stage and have that design stage as much as possible reflect the lived experiences of the communities in which these tools will actually be operating, and that's going to be a much better prophylactic against harm than simply being mindful when you're in the field.
Super, Ryan. That was extremely rich. Any final closing remarks you'd like to give?
No, I mean I think there is a fundamental set of tensions. I don't want to downplay that. I think that you do need information and the ability to analyze it in order to do great work in the world. There's a tension between keeping people's information privacy and being accountable through transparency. These are real struggles, right? But they're critical and they're important, and I hope and expect that the World Bank and others will be up to it. But anyway, thank you so much for allowing me to speak today.
No, thank you. And thanks to all the panelists and for all of you who stuck around to hear this final presentation, because I think you're richly rewarded if you did. We hope you've enjoyed the event and the rest of World Bank Privacy Day. And take a moment to check on the heat maps on your way out, and we'll see you all again next year. So thank you very much.
Right. Thank you.